And we are recording.
Okay, great. Let's call the meeting to order. Sunshine Ordinance Task Force, May 5th at 4:01. Cheryl, take it away.
Hang on a second. Remote access to information and participation. In accordance with Governor Newsom's Executive Order N3320 declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London N. Breed's proclamation declaring a local emergency issued on February 25th, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. Shall I do the vote? The see who's here, the attendance?
No, you have one more sentence, and then I have to do meeting.
Right. Yep. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process.
Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and or menacing behavior may be asked to leave. I'm going to add that if there is any offensive language that any of the task force members might experience, they can call for meeting decorum, and we will deal with it at that time. This will allow for a disruption during any public testimony. Period. Thank you. Okay, item number one.
Number one, call to order, roll call, and agenda changes. Roll call. Chair Wolf?
Aye, here.
Chair Wolf present. Kai Forsley?
Here.
Kai Forsley present. Laurie Jones-Neighbors?
Present.
Laurie Jones-Neighbors present. Chris Highland?
Present.
Chris Highland present. Matthew Yankee?
Present.
Matthew Yankee present. Laura Stein? Laura Stein? Laura Stein not present. Jennifer Wong?
Present.
Jennifer Wong present. Jaya Padmanabhan?
Present.
Jaya Padmanabhan present. Kevin Frazier?
Present.
Kevin Frazier present. Lila LaHood?
Present.
Lila LaHood present. Dean Schmidt?
Present.
Dean Schmidt present. We have a quorum.
Okay, thank you. Any changes or adjustments to the agenda?
I just want to mention Laura Stein is present.
Oh, you are? Oh, okay, great. Thank you. I didn't hear you.
That's all right.
Okay. Agenda changes. I know of one. Item 8, file number 20092. Yesterday at about 3:30 in the afternoon, I received an email from Carl Kramer, who said that he had received all his records from the Department of Recreation and Parks and wished to withdraw his complaint.
Great.
Okay, thank you.
And then this afternoon, about a half hour ago, I got an email I was CC'd on an email from Mr. Andrews. His case number is 20079. He said that he is inclined to accept the district attorney's response and take today's hearing off calendar. So perhaps we should ask if, when that case comes up, if Mr. Andrews and the respondent are here today, because I got this email at 3:17 today.
Well, why don't we deal with that now? If either of the parties are here and we can dispense with it, we'll at least know whether it's going to happen or not. So is either of the parties here?
Mr. Andrews, this is Shane Andrews for Tom Mosley. I am here.
Okay, and what is the status of this file at this point?
So just to elaborate, yes, I had sent an email to Ms. Burke of the District Attorney's Office because I had received a letter from her yesterday just confirming what she had done with respect to searching for documents in response to our request, essentially just reiterating the previous response of
We
no
just
public
need,
documents.
Mr. Andrews, we just need to know whether we're going to be hearing the case tonight or not, or whether you're going to pull it.
Yeah, no, you're right. I'm sorry. The point being is, I said if I would pull it, if she could confirm one or two things, and I haven't received an email response. So as of now, unless she's here and wants to jump on and confirm, then I would say that I still need to go forward, I guess.
Okay, is there a representative from the District Attorney's Office present? Calling for a representative from the District Attorney's Office. Okay, hearing none, then we'll ask again sometime during the meeting before the item comes up, and we'll deal with it then. Any other changes to the agenda?
As far as I know, those are the only two changes that came up.
Okay, members, any changes? Adjustments, corrections? Okay, hearing none, let's move on. Please call next item, Mr. Leger.
Okay. Item number 2, approval of the minutes from the Sunshine Task Force Rules Committee of September 24, 2019.
Any changes or adjustments, edits to the minutes?
This is Vice Chair Yankee. I have just a couple here.
Okay. Matthew, hang on so I can follow what you're saying.
Sure. Let me know when you're ready, Cheryl.
Okay, I have the minutes in front of me. What's your comment?
Okay, so I think that Fiona Hinsey, me, and Chris Highland were the ones scheduled to be there, but I believe Member LaHood and Chair Wolf joined us as well. So I noticed Member LaHood is listed in the roll call, but Chair Wolf is not. I don't know if we ordinarily list additional members who join who aren't normally part of the committee in that section or not. If we do, we should probably list both of them since they were both present. And then the second correction was on the motion to the meeting minutes. Just the 3 of us voted, but you have the ayes as 4.
Oh, 3. Right. Very good point.
So those are the 2 things.
Any other changes or adjustments to the minutes? Okay, hearing none. For before I take the let's get a motion on the floor.
Sure, I'll go ahead and move to approve the minutes with those changes.
I'll second. This is Lila.
Please.
Member LaHood.
Okay, so moved by Vice Chair Yankee, second by Member LaHood. Please, for open public comment, please.
Are you taking public comment now?
I just announced public. Yes, I announced public comment.
Give us a moment. I think we're waiting for Cheryl to get back online. She might be having some issues.
Mr. Warfield, is that you?
Yeah,
Yes.
Cheryl, you can go ahead and take public comment if you're ready to time it.
Yeah, I just had to go get my timer. That was it.
Okay.
Are you ready, Mr. Warfield?
I think I am. Thank you. Yes. Tell me when to start.
Go ahead.
Hi, this is Peter Warfield, Executive Director of Library Users Association. And I say these things because in a normal meeting, people could see each other, people would know who is speaking, could come up to me, or I could go up to them and identify, exchange information about contact and so on. As it is here, I don't even know who is attending or if there's anybody attending other than the members. So I give the contact information, which is libraryusers2004@yahoo.com, and by mail, P.O. Box 170544, San Francisco, California, 94117. Thank you very much for providing these minutes. I just have a few questions about that process, and that is, it seems a very long time since since the meeting occurred, and so I'm wondering why it looks like about 1.5 years. I guess I understood somewhere along the way, and I can't quite say where, don't recall exactly, but it seems as though I understood that if minutes are not approved by the committee that had the meeting, and I thought I heard something like 6 months, then it would come to the full task force. So this is quite a lot longer than 6 months. I'm wondering if there is a procedure and how that's working. I'm curious about something I've seen occasionally that I don't recall seeing before, and that is at the end of the meeting minutes, it talks about, it says NB, and says that the chronological sequence may not be the same in the minutes as what actually happened. So I'm not sure why that says that. It seems to confuse kind of the issue, and also if somebody wants to listen to the recording, they might have trouble finding what's going on if the minutes don't reflect what the sequence was of the actual meeting. I've also noticed in some minutes a very helpful thing, which is timing notes that show when in the recording a certain item
30 seconds, sir.
Thank you. That shows when the item is on the recording, 38 minutes in until 1 hour and 5 minutes out, and so on and so forth. So I'm wondering what your procedure is for that. These minutes don't seem to have any of those timing notes that are key to the recording. Thanks very much.
Is there another public commenter?
Any other public comment for the minutes? Okay, hearing none. Are we ready for a vote? Please call the roll.
Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Frazier?
Aye.
Member Frazier, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member Hyland?
Aye.
Member Hyland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to approve the minutes, the roll committee minutes of September 24, 2019 has passed.
Okay, thank you. Please call the next item.
Approval of the minutes from the Sunshine Ordinance Task Force April 7, 2021 meeting. I have a copy of those minutes. Does anybody have any changes?
Any changes or adjustments to the minutes? This is for the meeting of April 7th.
Do we want really small changes, like just misspellings or things like that?
Yes.
Mm-hmm.
Okay, then I can give a few. On page 9, under number 2, third line, it says Member Stein request. Should be requested.
Wait a minute. What number is it? Item 2, item 3?
Item 2, third line down. Just requested.
Comment on previous action / requested correction?
Sorry, I'm looking at P9, which is actually on the 3rd page.
I know, I understand you're looking at P9, but I don't have that up. I have my notes up, and I have a copy of the minutes.
Approval, it's number 2, approval of minutes from the
Page-
Sunshine Ordinance
Page
Task Force.
2.
Page 3 on the file, on the PDF.
Item 2. Could you read that language again, please? I'm sorry, I'm taking so much time trying to find
Okay,
it.
are you on page 3 of the PDF?
I'm looking at a hard copy of the minutes. I printed it out, and that's what I'm looking at. I'm not
Okay.
looking for anything on a computer.
Okay, then I guess it's page 2 of the minutes if you don't count the cover sheet.
Yeah.
And it's item 2, 3rd line down.
Member Stein requested that the question mark
Yeah,
be
requested instead of request.
Okay.
And then similar thing on page 3 of the hard copy, I think, under item 3,
Okay.
7 lines down, starting with member LaHood,
Yeah.
would be provided. And then page 4,
Okay.
it says, the first line says SOTF referenced section 67.31 in urger of the mayor. I don't know what that is actually supposed to say.
I think it's supposed to say to urge.
Oh.
R is supposed to be there.
And then just for the sake of it, item 5 on that same page, 6 lines down, Ann Turbo noted the passing of, it should just say Lawrence Ferlinghetti.
F isn't, oh, F, not P?
No, it's F-E-R.
Yeah, I got it.
L.
Yeah, I get it.
Okay. Then the next page, which is page 5 of the hard copy. Ooh. Second paragraph. 6 lines down. Just something's funky in there. With out of the office with appropriated out of office information provided. I guess with appropriate out of office information provided. I don't know, maybe I should submit these later. There were just so many, well, actually there's just a few more, I guess.
Just go ahead and tell me and I'll fix them.
Okay, and then on the next page, which is, I think page, where is it?
Page 6.
Yeah. Item 7, in the paragraphs that starts with action in bold.
Yeah, that's the action.
Yeah, it should just say did not violate, not did not violated. And then under item 8 on that page, the 4th line down, I think it should say by failing to provide instead of failing to aid. And then
Wait a minute.
line after that,
It says failing to provide. Oh, I see. Failing to. Fix the word. I see it.
okay. And then the line after that, it says failing to keep withhold. I guess that's failing to keep withholding.
Holding, yep.
And then the next line after that, again, by failing, it should say by failing to provide, not by failing by provide. And those were the ones I caught.
Okay. I will make the corrections tomorrow morning. Repost them. Thank you very much.
Sure.
Any other changes or adjustments to the minutes of April 7th? Okay, hearing none, is there a motion to approve the minutes? And then we'll call for public comment for anything else.
Member Highland, I'll make a motion to approve with amendments.
Member Frazier, I'll second.
Moved by Member Highland, second by Member Frazier to approve the minutes with the current edits. Let's open it up for public comment, see if there are any more.
Yep. Am I muted or?
Hold on, wait for Ms. Leger to call. She may not be ready.
Mr. Warfield, are you ready now?
Yes.
Go ahead, sir.
Yes, this is Peter Warfield, Executive Director of Library Users Association. And we can be reached at libraryusers2004@yahoo.com and also by postal service at P.O. Box 170544, San Francisco, California 94117-0544. Excuse me. I think at a previous meeting I talked about the importance of name and people being recognized and people being seen when they are particularly wishing to be recognized. And so first of all, I appreciate that on these minutes, it looks like the affiliation with Library Users Association has, on the whole, been made when I have spoken. But there has not been a single contact information included, even though I believe I spoke the contact information at every time that I did speak. I'm sorry, I can't hear what?
Can everybody please mute?
I beg your pardon?
Just hold on a second. Please hold the clock. Can everyone please mute? Member Schmidt, can you mute, please? Thank you. Okay, please continue, speaker.
So how much time do I have left, please?
Mr. Leger?
Sorry, it's muted. 1 minute, 29 seconds.
So I have a minute and a half left, right?
Correct.
Thank you. So as I was saying, identification, people say his name, say her name, and so on. As I have said, the ability to have a public presence, to be seen, to be heard, to be able to approach people, to be able to be approached, is not there on the remote meeting. And so I would appreciate having the full identity included, which is to say Executive Director, Library Users Association, and the contact informations. With respect to the content, I am glad that you took the time to take the details from, I guess, Ms. Stein. And I would appreciate if you would do the same with my
30
suggestions.
seconds.
And so the first thing to be said is on item 2, it says, it was noted, and then there's that Peter Warfield commented, and something or another should be corrected. Well, who noted it, and how is it supposed to be corrected? Item 8 also lacks some specifics that I think would be useful to include. And again, the timing notes are not in. It would be great to have those. And I don't know if the NB note is at the end, but I don't know if it's there. I don't know what it means, but the timing notes would be useful. Thank you.
Next speaker.
Anonymous, please.
You ready, sir?
I am.
Okay. Go ahead, sir.
Thank you very much. I would like to thank the member for pointing out all the detailed corrections. It's actually, I think it's really useful because, of course, these minutes get copied into your orders of determination, and by and large, your orders of determination are the kind of the output work product of this task force. And for that reason, I would ask that you add a little bit more detail in both files 19124 and file 20066. It's not clear what the cases are about just by reading the summary. And so I would ask that you add into the sentence, Anonymous stated that police department procedures of redacting and producing documents were incorrect. Just the phrase redacting and producing SB 1421 documents were incorrect, so that someone knows what this was about if they read the order of determination later. And I would also ask that you add in file number 20066, it just says Anonymous provided various code references and explanations in support of their argument. But what argument does it mention? So I would ask it to say Anonymous provided various code references and explanations in support of their argument that the police commission cannot cite Penal Code 832.7 B6, since that's what the case was about, and that's what you decided. I understand that people say, well, Anonymous and the SFPD and the police commission were there. They already know who won and lost what. But to me, at least the reason I bring these complaints is to have written determinations of what is and isn't allowable under the Sunshine Ordinance that people after me can then use to make sure they get the records that they are owed. And so I'd ask that you add these details so people can look at your orders of determination and know what, why or what were these cases about. Thank you.
Next speaker. Okay, I just want to ask the last speaker with regards to the minutes versus the orders of determination. Are you saying that's the same verbiage?
Would you like me to respond?
I do.
From my own orders of determination, what it appears is that these summaries get copied and pasted into the orders of determination. At least that's my understanding.
Okay, so I will be more diligent to review that. But just for the minutes, because all our meetings are recorded, any further details can be found on the recordings. I do understand what you're asking for, and we'll do our best to provide at least that much substance. So it kind of, I understand it. So it makes it a little more clear. I get that. So thank you for the response. Any other public comment on these minutes? Okay, hearing none. Members, for the maker and the seconder of the motion, is there any amendments that you would like to add to your motion with regards to what the public commenters have brought forward? Or for anyone else, is there any amendments to the motion?
None here, the maker.
Okay. So we'll, we have a motion on the floor made by Member Highland, second by Member Frazier, with the edits that were brought forward by Member Stein. No further edits are being considered at this time. Are we ready for a vote? Okay, please call the roll.
Member Highland?
Aye.
Member Highland, aye. Member Frazier?
Aye.
Member Frazier, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to approve the April 27, 2020 Sunshine Task Force meeting minutes with amendments brought by Member Stein has passed.
Thank you. I just want to announce that we'll be taking a short recess at 6 o'clock, and I'm going to do my best to try and keep our hearings to under 45 minutes. And if we hit a 45-minute mark and we haven't come to any motion for determination, then we'll deal with it at that point, whether we want to forge ahead or not. Okay, let's call the first item, the next item, number 4. Mr. Leger?
Yes. Item number 4, file number 19144, complaint filed by Anonymous against the Department of Police Accountability, Paul Henderson, Diana Rosenstein, Stephanie Wargo Wilson, and Mary Polk for allegedly violating Administrative Code Section 6721, 24, 26, and 27 by failing to respond to a public records request in a timely and or complete manner, failing to assist in a timely and or complete manner, failing to cite lawful justification for exemption, failing to key redactions by footnotes or other clear references to justifications, and failing to withhold the minimum portion of records. This complaint was heard December 20th by the Compliance and Amendments Committee. The records were found public and the matter was referred to the task force.
Okay, before we start, I'm just reading the intake form, and I just want to ask the petitioner regarding a notation that was made. Says STF has not heard file 19127 anonymous versus DPA et al. For merit yet. Therefore, if you have the power, I'd ask that the task force combine, not replace, this complaint into SOTF 19127 for efficiency. Is that what is happening here today, or are you going to make a request for us to do this today?
No, I believe I withdrew the other one. That one was something else, just against the same agency. All I care about is this here today. Okay,
very good. Thank you. Then let's hear from Compliance Amendments Committee Chair LaHood.
Yes.
There's anything to report on this?
This is going to be the first time that this is heard by the full task force. We found jurisdiction and that the records are public. One thing I would like to note, and I didn't mention this earlier because this wasn't about minutes, but the Compliance and Amendments Committee meeting where we heard this was December 22nd. So I know that's a minor thing, but I know as going forward, if we could.
December 22nd, okay.
Yeah.
Oh, it's just a correction in the agenda. Okay.
In the agenda, and I guess for anything going forward that might reference that. And it was just because I went to look something up and I noticed that the 20th was a Sunday.
Okay. We'll note that for the record.
I noted it. I'll make the correction.
Okay, great. Okay, Ms. Leger, if you're ready with the clock, we'll hear from, well, let me just ask, Chair LaHood, was there anything you wanted to report at a committee regarding this?
Not in particular. I think we just need to hear from the parties.
Okay, great. So let's begin. Petitioner Anonymous.
Please let me know when I may start.
You may start.
Thank you very much. Good evening, Task Force. This is an SB 1421 complaint versus the Department of Police Accountability, fairly similar to the two SB 1421 complaints you heard last month. The update as of when we had to file papers for today's meeting is on P300 or PDF page 284. So this is another omnibus SB 1421 complaint made in November of 2019. The issues have been narrowed down. We're not going to discuss timeliness or anything like that. The issue basically is that the DPA was not following sunshine rules with regards to SB 1421 records. I even told them about this. They didn't change their tune. And so we have this complaint. So the first issue is 6727. Not until months after I filed the complaint did they start producing any written justifications for withholding. They're doing that for new SB 1421 productions, but they were not willing to agree that they must do so and correct their prior ones, i.e. the ones at issue in this complaint. There's a multiple different 6726 issues. The most obvious one is not until February of this year did they start keying redactions to the above those written justifications. And again, they were not willing to agree in writing that they must correct all prior productions. There are issues like those keys aren't correct, but again, I think I'm not allowed to discuss that here, and I would have to discuss that in compliance if you agree at all that they have to produce keys. We did not know what exactly the records they were withholding. We've found out now that they were withholding an entirety audio records. I am not going to ask you to do anything about that because they have entered into a written agreement that they will go back and produce all the old audio records. Next page. They're also withholding in the entirety video records and index records. And as with the audio issue, their argument was that video records and index records are costly to redact. As you know, in San Francisco, that is not an excuse to not produce records. And as even statewide, as of the National Lawyers Guild versus City of Hayward case, they can't use this, they can't kind of put the cost of redaction on me or any of the other SB 1421 requesters. As far as I know, I don't have a written agreement with them to do video records and index records correctly. And then finally, there's the use of the impermissible balancing test, Penal Code 832.7b6. And this was prior to the mayor's fifth declaration regarding COVID. They told you at the committee that, well, Anonymous can't point out exactly what stuff we withheld under Penal Code 832.7b6, and they're right. I can't because they didn't give those keys, right? But I don't think it's fair to say, well, because they didn't follow the law by telling me, you know, which things are being redacted underneath that, that means that that's not a violation, right? And I think I've already successfully argued that Penal Code 832.7b6 is not a permissible balancing test, as all of you agreed last time with the police commission. So, yeah, I would ask that you find these violations. SB 1421 records work just like any other records. SB 1421, all it does, it says that records, police personnel records that used to be exempt under the CPRA are no longer exempt under the CPRA, certain subsets of them. And all the sunshine rules apply. They have slowly come to accept that in most portions, but you know, it's not, some of them apply, all the rules apply, and they should comply with them for all SB 1421 records. I don't think I have anything else. Thank you very much.
Thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner? Okay, hearing none. Respondent, Department of Police Accountability, is their representative?
Hello, this is Sarah Monder appearing for DPA. May I proceed?
Wait for Ms. Leger to reset the clock and tell you when to begin.
Thank you.
Are you ready?
Yes.
Go ahead.
Okay, thank you. So this matter is about an immediate disclosure request for all of DPA's qualifying SB 1421 records. The request was made on Thursday, November 28th, 2019, which was Thanksgiving Day. Our office was closed for business that day and the following day for the holiday. The following Monday was December 2nd, 2019, and that's when our staff first received and responded to the request. A DPA staff attorney sent an email denying the demand for immediate disclosure and explaining that the request was not simple, routine, or readily answerable because it was voluminous. The same day, a DPA clerk also responded and explained that we were working to provide all of the previously produced records. The very next day was December 3rd, 2019, and we provided records for 16 cases that had been previously produced to other requesters. So that satisfied the first part of the request. Then on December 9th, 2019, which was 7 days after we initially received the immediate disclosure request, we emailed explaining that we had sent all previously produced files, that we were going through a very large project of reviewing thousands of paper files and offsite storage dating back to the 1980s, and that additional files would be provided on a rolling basis as qualifying cases were identified. After that, we began sending the petitioner case records on a rolling basis as we continued to identify cases for disclosure, redact them, and process them. Then our office was shut down for business by emergency orders on March 17th, and on March 23rd, the mayor issued the 5th supplement to her emergency proclamation, which suspended many of the provisions of the Sunshine Ordinance. In August 2020, we debuted our new public records portal where we uploaded all of our previously produced files, and that is where we continue to publish newly released files. Then in January 2021, we made cover sheets for all of the files on our portal to explain all of the previous redactions that were made. In February 2021, although the mayoral suspension is still in place, we began keying all redactions with all redaction markings with codes. And to do that, we use overlay text, white overlay text on the black markings. And to make it easier to read, we use shorthand codes like PII for things like personally identifiable information. And now the first page of every case that we produce comes with a cover sheet that explains what each of the codes mean for the redactions. To date, we have released over 27,000 pages of records. They're all publicly available on our portal. And so to summarize and address the issues identified in the initial complaint, I believe that DPA has timely complied with the immediate disclosure request by responding on the same business day that the request was received, and by providing records the very next business day. We also, 7 days later, responded with a statement of the nature and quantity of records that we were remaining to produce to the best of our ability. We provided the cover sheet to justify previous redactions, and we are now adding keyed codes to our redaction markings as we release cases. A few issues have been raised about failing to keep redactions to a minimum. We've done our best to redact a minimal amount of information. I don't believe we have any specific redactions to discuss for this complaint tonight, but I'm happy to answer any questions. The petitioner brought up some issues about the case that we released in February 2021, and although I believe that is a new and separate complaint for this task force to consider, I'm also prepared to answer questions about those redactions if the task force desires. Thank you.
Thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the respondent? Okay, hearing none, we're now in our question and answer discovery portion. Members, please direct or formulate your questions to gathering more information. After we hear rebuttals, we'll have deliberation on what we found and the merits. Floor is open to you.
Chair Wolf, I have a question.
Member LaHood, go ahead.
Yes, for Ms. Maunder, could you speak specifically to, it sounds like you have an agreement with or your department has an agreement with the petitioner regarding audio files. Can you give us your perspective on the status of video files and the requests for video files?
Yes, we do plan to release audio and video files for our SB 1421 cases. Currently, we are only releasing transcripts for audio files because we are waiting for permission to purchase the technology that would allow us to redact the files and we need a technology solution that complies with CGIS information security because we deal with law enforcement files. So we are working on that issue, and because of the purchasing rules for the city, we are waiting for Board of Supervisor approval to purchase a solution that will allow us to redact those files.
Thank you. Do you have is there a projected time? Do you have any idea how long that might take?
I wish I did. We've been trying to purchase this solution for several months. So I apologize. I do not have a projected time for that purchase, but we are anxiously awaiting receiving permission.
Thank you.
Member Schmidt?
Yeah, I have maybe a series of questions for the petitioner. And this is about, it's a legal question. You've got a legal analysis on section B6. And I think we've talked before about this. I'm trying to figure out your analysis here. And this is where I'm going to start. You make a distinction, and I've seen this in your paper several times, where you talk about mandatory exemptions in state law versus permissive or voluntary discretionary. First, do you know what I'm referring to, petitioner?
Yes, I do.
Okay. Now, in terms of, you make a distinction, and first you, I believe, acknowledge this category of mandatory exemptions. And is it true that you're saying to us that in terms of these mandatory exemptions, state law would govern as opposed to a contradictory local law?
I want to be very precise in what I'm saying, so it's not held against me later. I am saying that the 4 subclauses of Penal Code 832.7B5 cannot be overridden by local law because it says, I don't remember the exact words, but the agency shall redact. So I believe that falls under Admin Code 6727B, which is a prohibition on disclosure. And so if the state prohibits you from disclosing it, there's nothing local law can do. That's my view on that specific issue.
Okay, so the word prohibition, is that where you come up with the distinction that you've been making between mandatory and permissive exemptions in the state statutes?
Correct. So what happened, this complaint is the reason why I had to distinguish between these, because if you read the original response from the DPA, they claim that the state is requiring them to do these redactions even in B6. And what I'm pointing out is, no, the wording of B5 and B6 is different. B5 says you shall redact, and B6 says you may redact. And therefore, that B6 is a permissive exemption. That's the word of the Sunshine Ordinance in 67.27A, which is that you're allowed to use any permissive exemption in the CPRA or elsewhere unless it's prohibited by local law. And so my argument is that state law permits local agencies like the DPA to redact based on a balancing test. It doesn't require them to, but it permits them to do so. And our local law says you can't use a balancing test according to 6724I. The same exact argument I made in the police complaint. Yeah.
Okay, so you're saying that B5 is usable in San Francisco, but B6 is not usable, and it actually is the use of B6 is eliminated by the provision in the local ordinance. Is that correct?
Correct. I believe Admin Code 67.24I prohibits San Francisco agencies from using, exactly as it says, Government Code 6255 or other balancing tests, such as in this specific case, Penal Code 832.7B6, and that is reflected in the distinction between Admin Code 6727A and Admin Code 6727B. And I apologize if in the last thing I didn't explain this clearly. I'm not saying permissive exemptions are banned in San Francisco, not at all. Most of the CPRA's exemptions are permissive. What I'm saying is permissive exemptions that are also explicitly prohibited by local law are prohibited. That's what I'm trying to say.
Okay, and this distinction you're making that would permit the respondent to use B5 but not B6. Other than you've said, I believe that. Do you have any other law, any other case law, anything else other than the argument you've given us that supports this argument?
I don't know of any court case that has ever tested Admin Code 6724I to see whether it works or not. So, no, to be very clear, the reason I'm saying B5 is allowed not because it says shall redact. It's the things in B5 are not prohibited anywhere in local law. B5 is not a balancing test at all. It's a specific explicit exemption. So.
Okay. That's all I have for now. Thank you.
Anyone else? Vice Chair Yankee.
Yeah, just a quick question for the respondent. I believe Anonymous discussed that some of the prior records did not have keyed redactions. Were you planning to go back and provide redaction keys for all records that you turned over?
What we did was publish cover sheets for those cases explaining the redactions. We currently don't have any plans to go back and redo those case files.
Maybe can you be a little more specific about what that is? I mean, are they specifically keyed for each of those redactions, or is this just like a general statement you made on the cover page?
Yes, it's a general statement that we made on the cover page explaining that most of the things redacted, well, all the reasons that we could redact, and that the things were redacted to preserve the personally identifiable information, the anonymity of complainants and witnesses, and other all the reasons from SB 1421. So it's a general statement that covers each of the files that we produced. And part of the reason we did that is the constituents that we were talking with when SB 1421 first went into effect, we were prioritizing getting out a volume of cases very quickly, and that was a compromise that we settled on. So those files have already been produced, and currently they just have the cover sheets on our portal so that you can see what types of redactions were made, and a lot of them are very self-explanatory. You'll see a form and it has something that says name, and then you'll see a black box, and a person's name will be redacted.
I guess the part that I'm still unclear about, or is it one reason that you're using for all the redactions, or are there a variety of reasons for a variety of redactions?
There's a variety of reasons.
Someone might need to know that reason 1 applies to the redaction on page 1. Reason 2 applies to a separate redaction, right? They need to be able to match up each redaction with that specific reason. I'm not sure that that's clear based on what you're describing.
Yeah, you're correct. They do not correspond. The redaction markings themselves don't correspond with a redaction reason.
Okay, thank you.
Member Jones Neighbors.
This question's for the respondent. I'm wondering if you could help me understand. This is something I go back and forth with a lot, but I'm thinking in terms of your redactions under PC 832 7B5 for personal info of officers. Can you tell me when you're making those redactions, what are the parameters that you use for personal information of officers? And is that based on a legal definition, an agreed upon definition? Who decides that? Is it, is it concrete? Can you just tell me a bit about that decision-making process?
Sure. So when we are redacting personal information for officers, it's not their name or their star number. It is their home address, their date of birth, their personal telephone numbers, that type of information.
So nothing more than that. No any other kinds of identifiers beyond that.
And you referenced a code section. Was that 832.7 B5 A?
Yes.
Let's see. There's also B5A also includes identities of family members. So we have personal data or information. It's a such as list. So we start with the idea of home address, telephone number, but there are other ways that the information can present itself that you might not think of. So we might redact a reference to a spouse to protect the identity of a family member.
Okay. And so, one of the things I noticed was that one of the concerns about the redactions also was that there's a requirement that redactions, the name of the redactor is the person who withholds information is identified, and that was not the case in the records that were released. That person wasn't identified. But were you able to go back then and identify that person or share that information so that we can maybe ensure that that person has the same definitions for the redactions that you're giving us?
So we're all working on the same definition, basically just using the penal code section and also the protocols published by the San Francisco Police Commission. The person who redacted is the attorney who signed for the production letters. So if there's a particular file that you want to know who redacted it, that we can provide that information. But when a case is produced to a specific requester, it's accompanied by a letter signed by an attorney, and that is the person who's responsible for the redaction.
Okay. So if there are cases, so if there were cases where that was missing, that would be something that you would want to correct.
Are you asking about a specific case? Sorry, I'm not clear.
Well, it seems like there was that there was for at least 4 of the documents, D2, 3, 4, and 5. There were no release letters for those documents provided. So that means that there wasn't an attribution for the responsible party.
Oh, got it. Yes, we could provide that information.
Okay.
Anything else, member neighbors?
No, thank you.
Okay. Any other questions or clarifications, members? I have one question, or I have 2 questions for the respondent. What citation of law are you applying to convert the immediate disclosure request to a standard request?
We did not convert any. I'm not sure. We didn't convert any request to a standard request. We still treated it as an immediate disclosure request. When it came in, we just responded, so an immediate disclosure request requires a response within a business day. We did respond within a business day. We responded on the same day. And then the next day, we provided all of the records that we could provide within that time frame. And then the rest of the request is now going to be complied with on a rolling basis because it was for hundreds of thousands of files and audio and video files. And so those will, the request is kind of bifurcated. The part that we could comply with for immediate disclosure, we did as soon as possible, and the rest of the request, we will respond to on a rolling basis.
Okay, so I'm a little confused because you use some kind of boilerplate language that we constantly hear that sounds like you converted the IDR to a regular request because it's voluminous. Did I hear that incorrectly?
Oh, I did say that,
Yes.
but I don't consider it a conversion. We complied with it as quickly as possible within the spirit of the immediate disclosure request, and then some of it just we could not produce.
Okay, and thus you provided it on a rolling incremental basis.
Correct.
Okay. I just wanted just a bit of a caution because we do hear that from other respondents, and they do intend. Their intention is to convert it from an IDR to a regular request under 6721 request, removing the 6725 provision. So I just wanted to get clarification on that. The second question I have is, so I just want to come back to who performed the redactions. It sounds like there were multiple people that did those redactions. Is that correct?
Yes, that's correct.
Okay, and were they done all by attorneys, or were they done by other staff?
It was a group effort. So pages were scanned in by a legal assistant, and some of the redaction markings were done by legal assistants. And then the cases are always reviewed by an attorney who then approves redaction markings and may remove or add additional redaction markings. So the person ultimately responsible for the case is the attorney who signs the production letter.
Okay, great. Thank you. Let's see. I have, let's go to Member Frazier, then Member LaHood, and then Member Neighbors.
Thank you. This is for the respondent, and just briefly, you mentioned that there are time-consuming and expensive burdens to producing video files. I was wondering if you all had an estimate or just a general ballpark of how that was determined and what that kind of threshold and criteria is.
The technology solution that we would like to purchase costs about $100 per hour of media redaction, which is the cheapest that we have been able to find. If we send it off-site to a vendor, it could cost $500 per file. We first transcribe the audio recordings to aid with the redaction of video or audio associated with it. So the whole process of producing media is just very, very expensive. Did that answer your question?
Yes, thank you very much.
Okay, Member LaHood.
Yes, so I guess my first question is to the petitioner. You submitted your request on Thanksgiving Day, is that correct?
I don't, is that November 28th? I know it's November 28th, so.
Okay, well, this is relevant to my question because, so for the respondent, is it correct that you believe that the request was initially submitted on Thanksgiving?
Yes, at 1:53 a.m. on Thanksgiving.
So on Thursday at 1:53 a.m. Was your office open on Friday?
It was not.
Okay. So your office was not open on Friday, so the following Monday was the first business day after the receipt of the request.
Correct.
Okay, thank you.
Member Neighbors.
Thank you, Chair. Sorry, I forgot to ask this question earlier. This is for the petitioner. I noticed in one of your emails that you mentioned that the records were only released via Microsoft OneDrive and that you had to authenticate in order to access the records. Has that been rectified, or are you feeling that you are still at risk of needing to identify yourself in order to get the public records?
For the new records, they have placed them on a public portal, but they only started doing this after I filed the complaint some time after that. I want to be clear, I did not ask you for a violation on that because I did not realize that until after I filed the complaint. So.
Okay, thank you.
Okay, last call for any questions or clarifications on discovery. Okay, are we ready for rebuttals? Okay, respondent, you are first. 3 minutes for rebuttals. Ms. Leger will let you know when she's ready.
Respondent, are you ready? Hello? Oh.
Sorry, what was that?
Are you ready to speak?
Oh, I have nothing further.
You have
For the respondent?
Yeah, this is for the respondent for rebuttals, any rebuttals you may have.
Oh, I apologize. I have nothing further to add. Thank you.
Okay, petitioner.
Thank you very much. So I'm just going to clarify what I am and I'm not asking for. But to be clear, I have not complained about the timeliness of their issue. There's no 6725 issue, so Thanksgiving or no Thanksgiving, obviously there's a lot of records here. Obviously they can take rolling responses for however long they need. That's not an issue here. And I believe they did respond in one business day. What matters here is that the same exact issues I brought up with the SFPD and the Police Commission, which is that SB 1421 records fully follow Sunshine. There's no hole in the Sunshine Ordinance with CPRA that this task force, I believe, should kind of create for these extremely important records of police misconduct. And so I would, and while the respondent has told you what they're doing, she has told you what they're doing now, not what they were doing in November or December 2019 when I filed this complaint, which is all the information I had. They did not give cover letters when I filed this complaint. They were just giving out records. So there was no identification of any of the justifications, even if they just want to say, well, it's all under all the justifications. Not even that was given. So even 6727 was being violated at the time. 6726 is still being violated for all the records they gave me originally. There's not an exception that for large records they don't have to key the redactions. You've never held that in any other case. And I don't think you should make an exception now. That's not what the law says. The right answer is to give rolling responses just like you made the SFPD do, and then key the redactions appropriately. And to be clear, a question was asked of them about video records because they'd agreed on audio records. I believe they told you what they were doing, how they're going to do audio records, but there's no progress being made on video records. And SFPD has to give me all the body cam footage. And everyone else, they properly redact it. They use their tools. This is not the kind of information that we can just let go because it's hard to produce. It's not appropriate doing that in any public records request, and I'd say especially in the case of police misconduct records. The records that are being fully withheld due to cost of production need to be produced, and I don't think there's any. I don't know why they wouldn't be. The San Francisco law doesn't allow that. And finally, 6724I, for the same exact reasons as you concluded in the case of the police commission, I don't believe they can. Thank you. They can use that. So I would ask you to do what's on the bottom of P301, which is page 285 of the PDF, which is to find the respondents violated 6727 for failing to justify withholding of information in writing, 6726 for failing to key redactions, 6726 for withholding the entirety of video and index records, 6724I for the impermissible balancing test, 6253D through 6721K for failing to state the name and title of every person responsible for denying access. And I believe that would then order the disclosure of the video and index records. Thank you.
Okay, members, time to deliberate and develop a motion for determination. Is there a motion?
Chair Yankee. Oh, I'm sorry, go ahead.
No, you go ahead. It's okay.
Oh, this isn't a motion. I guess it's just a quick question. I don't mean to go back to a question, but it was something that was brought up in the rebuttal that I'm just trying to understand here. And that was regarding the video records. And I believe Anonymous stated that the police department is able to redact these using existing technology that they seem to have. And so maybe the respondent can talk about why their department cannot utilize that same technology to accomplish that.
Yes, I can answer that question.
Are you, hold on, Vice Chair Yankee, are you asking the respondents
for? Sorry, yes, I was asking the respondent why they couldn't utilize that technology.
Okay, go ahead, respondent.
Thank you. Yes, so we are a separate agency from the police department. We have a extremely modest budget in comparison. We don't have access to the same technology tools. So it's my understanding that the police department is using Axon technology to redact their body-worn camera videos. And Axon is the company that owns and operates the body-worn camera equipment. So we do not have access to that technology to any sort of account. We don't have direct access to that footage. So when we receive video footage, we receive it like just a file, and it doesn't come with any embedded programming or any way to manipulate the file to, say, do blurring or to distort audio to protect the anonymity of complainants or witnesses. So since we're a separate agency, we need to purchase our own technology to make those edits to the video, and that is what we are trying to do right now. And the technology that we're trying to purchase would also enable us to redact other types of video besides body-worn camera footage.
Just as a quick follow-up, how long ago did you make the request to purchase that? I guess I'm trying to figure out where the delay is, because it seems like an incredibly important thing to be able to do. And I think it's concerning that it's taken so long. And so where's the holdup taking place?
I can't remember off the top of my head, but I believe it's been about 3 months since we've been trying to purchase. First, we tried other solutions. We tried out some other ways to potentially edit video. We found one solution called Veritone that works for our system and that is CGIS compliant. And we've put in a request to purchase it, I believe 3 months ago, and it was flagged as by the Surveillance Technology Ordinance for additional review by the Department of Technology, and it requires a Board of Supervisors vote for us to make the purchase, and we are waiting for it to be calendared, I suppose. And I'm not quite sure how that process works because the Department of Technology takes over at some point because it's a technology tool that we are trying to purchase.
Okay, so you're basically saying, just to make sure I understand correctly, that everything that your department can do to move this process along has been done, and it's now in the responsibility of another department to continue this process before you can implement the technology. Is that correct in what you're stating?
Yes, that's correct.
Okay, thank you.
Yes, member Neighbors.
I would like to set the video issue aside and make a motion for the remaining violations. And then we'll have them on the floor. We can do with them what we will. So
Please name them as you make your motion. Thank you.
That we find the Department of Police accountability in violation of 6727 for failure to justify withholding of information in writing, 6726 for failing to key redactions by footnote or other clear reference to a written justification required by 6727, 6724I for impermissible balancing test, and CPRA Government Code 6253D via 6721K for failing to state the name and title of every person responsible for denying access.
Okay, is there a second?
I was going to ask Lori if I could just review that motion with her before.
Sure, absolutely.
Okay. These are remaining violations.
Can I just interrupt for a second? We're right in the middle of a motion. I would wait until we get a second before we do that, because if there's no second, then it doesn't matter. Is there a second to the motion?
I'll second it.
Who's speaking?
Stein?
Oh, sorry, Member Stein.
Member Stein? Okay, great. So moved by Member Neighbors, second by Member Stein. Okay, Mr. Leger, you can go ahead and ask your question.
Motion for finding the Department of Police accountability in violation of 6727 for failing to justify withholding, 6726 for failing to key justifications, 6724I impermissible balancing test, and then you mentioned government codes, and that's where you lost me.
CPRA Government Code 6253D via Sunshine Ordinance 6721K for failure to state the name and title of every person responsible for denying access.
Okay. Discussion on the motion. Okay, let's go to public comment. Public comment is for any members of the public other than the parties. Mr. Leger, when you're ready.
Do we have a speaker, sir?
Any public comment?
Here's one.
Are you ready, speaker?
You tell me when to start, please.
Okay. Go ahead, sir.
Hi, this is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004.
Oh my God.
Beg your pardon?
Continue.
And by mail at P.O. Box 170544, San Francisco, California 94117. The We are not a party to this, and we're not familiar with this, but there was something that was said that I thought was interesting, and certainly would want to draw the attention of the body to, and that is the difficulty that the department, or the time it's taking the department to get approval of technology to redact videos. And I do believe that it was also said that hiring somebody could be a way to do the redaction that is required, or said to be required, and that would cost, I believe, I heard the figures, $100 or possibly $500. So it seems to me that video redaction at present may be more difficult for lack of technology, but apparently could be done by hiring somebody. And therefore, I think it should be taken seriously that the redaction requirement still falls on the department to take care of in whatever way might be necessary. So I hope that you take that into consideration and consider adding that as part of the list of violations, possibly here or possibly in a separate, but I'm not sure there will be another motion, so I would suggest including it or considering it, including the video issue with this motion. Thank you very much.
Oh, God.
Next speaker. Any other speakers? Public comment on this motion. Last call for public comment on this motion.
I have a comment.
Go ahead. Mr. Leger, if you're ready with the...
I am ready. Speaker number 2, go ahead.
Hi there. I work at, and I've been watching this police reform for a while, and I'm worried that the department re-redacting everything is just going to take a long time. I want these files out now, and I just don't see what we're doing here. That's all.
Okay, thank you. Next speaker. Any other speakers? Okay, public comment is closed. Members, any last words for this motion? Are we ready for a vote? Okay, hearing no objections, please call the roll.
Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein? Member Stein?
Sorry, aye.
Member Stein, aye. Member Frazier?
Nay.
Member Frazier, no. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt? Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion for remaining Department of Police accountability violations are 6727, failing to justify withholding, 6726 for failing to key justifications, 6724I, impermissible balancing test, Government Code 6253B, Sunshine Ordinance 6721K for failing to state the name and title of every person denying access. Is that
Okay,
correct?
just wanted to make sure on that last one, it's 6253D is in David.
Okay, thank you. Thank you.
Okay.
I didn't hear that.
Okay, great. Are there any other motions for this item? Okay, seeing none, let's go directly to our next item.
Item number 5, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Okay, I just want to preface this by saying, members, if you and members of the public, anybody who's speaking, please self-moderate. And if there's any offensive language that is deemed to be under our decorum provision, please interrupt and call it out, and I will take it from there. Thank you. Let's have the first speaker.
Hello, first speaker.
Well, maybe it is. It's me.
Hello, speaker number 1. Go ahead, sir.
This is Peter Warfield, Executive Director of Library Users Association, and I would ask the chair to ask whoever is making outbursts to not interrupt my public comment. There should be opportunity, if there is objection from somebody, to hear it. Anyway, this is Peter.
Mr. Warfield? Mr. Warfield, I think you muted yourself. Mr. Warfield? Excuse me, Chair, I'm not hearing from the...
Can you hear me?
Yes, we can hear you.
Can hear you.
I don't know what happened. I didn't touch anything, and then I heard a bunch of you're in, you're out, you're in, you're out. Did you hear that?
No, but please restart this time.
Yeah.
Okay, tell me please when to start, and do I have 3 minutes?
Yes, sir, you have 3 minutes. You may begin.
Thank you. This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com and by mail at P.O. Box 170544, San Francisco, California 94117-0544. And again, if anybody has objection to identifying who we are and how to reach us, I would certainly be glad to hear about it, but I think this is not the time for interruptions. I have 3 points to make. The first one is that I hope that the task force has already or will, members will attend remote meetings as members of the public. I have to say that remote meetings have many, many differences from the actual real meeting, and in fact are different one from the other. For example, your practice of not muting anybody automatically or during the meeting, I think is excellent. But other places you have to be muted and unmuted and so on to even get a chance to speak. And there's a whole range of things that people hear in the public when you're participating in public as a member of the public that not everybody is hearing or aware of or present with. So there's a whole range of differences, and I think also being in charge of the meeting is different from being an attendant, attending as a member of the public. And also I would urge you to try it by telephone, which is how some people, including myself, either have to attend or choose to attend. Second, I heard Supervisor Aaron Peskin at the Rules Committee January 25th, and he talked about some of the problems of the task force. He talked about a backlog as well as what he called a lack of staffing. I've talked about some of these things certainly, and it's a hell of a tough job to work on the task force and to administrate the task force. It's certainly not a job that I think many people could handle. But he immediately mentioned with lack of staffing, which we are hard-pressed to afford. That was a little discouraging. And then he talked about having spoken with the chair, who was one of the people being reappointed, and they had talked about some of the problems and some of the solutions, consolidating complaints, resolving at subcommittees or with facilitated and so on. And none of it included maybe looking into the tremendous number of complaints that are received and what the supervisors might do. Finally, I received a phone call from the chair who said there had been complaints about my public comments at a previous meeting, and I'd appreciate hearing directly from anybody who has an issue. Thanks very much.
Next speaker.
May I comment? Is it not?
Speaker, are you ready?
Yes, I am.
Go ahead, sir.
Thank you very much. So as I believe the Department of Technology informed one or two of you on the task force, and I believe it might have been the chair and the vice chair, the tool for metadata has been released. Agencies appear to actually be complying with your orders. They are releasing the information. The Office of the Mayor has actually offered a consent agreement that they will produce without fighting this anymore. The things that you have ruled now, I think 7 times on regarding exact copies, full email production. You get the email addresses, get all the attachments, you get everything that the government communicates. Oh yeah, and including the email headers and metadata. And I know that some of you who have been on task force much longer have said, you guys have been saying this for at least 14 years now. It's not something new, and it's really I think it's a really positive step that the government is actually complying with what you're saying, and I hope they do so more often than not. I know I hear other people's complaints. The government doesn't always do what you say, and they'll just sometimes say nothing and do nothing. They have no argument why that's not appropriate, and the whole point of the Sunshine Ordinance, at least one of the most important points, is that 11 volunteer members of the public with a wide diversity of experiences and backgrounds are the ones who get to decide what is public in San Francisco, what the rules the government has to follow, instead of the government deciding on its own what it can give the public. And I hope that the government does this in more cases, that they realize, okay, yeah, we're wrong, and they start complying with the law. Thank you very much.
Thank you. Next speaker. Any other public comment? Any other public comment? Last call for public comment. Okay, public comment is closed. Let's call our next item.
Item number 7, file number 20079, complaint filed by Shane Anderes against the District Attorney's Office and Chesapeake for allegedly violating Administrative Code Section 6721.
No, Mr. J, let me interrupt you. It's item number 6.
I thought we discussed that was one of the cases that was pulled.
Oh, was it?
Yeah.
It was the last one. It was number 8 that you told us that was pulled.
Number 6 too. 20077.
Okay.
All right. Well, I'll repeat it, and then we can make a notation in the minutes that it was closed. I mean, it wasn't closed. It was withdrawn.
Okay.
Do you want me to do that?
Yes, please.
Yeah. Item number 6, file number 20077, complaint filed by Tom Borden against Recreation and Parks Department. Oh, no, you're right. This was not pulled. This was another one. I apologize. Recreation and Parks Department for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and/or complete manner. I apologize. That was a different case that was pulled.
And the byline underneath it, please. Can you
March
read that?
16, 2021, the complaint committee found that the task force has jurisdiction to records of public and referred to the task force for hearing.
Okay. Complaint committee chair Schmidt, do you have anything you want to add?
Just that we forwarded it. It's pretty straightforward. I would defer to members of the committee. Do you have anything you think should be noted on this?
Where's my? If I recall correctly, I think there was some expression on the part of the respondent that they were going to get the additional materials to the petitioner, and I just would want an update kind of upfront from the petitioner about whether that happened.
Okay, we'll hear it when the testimony comes for sure.
Yeah.
Thank you, Member Stein. Any other complaint committee members have anything they want to add?
I do know there was some controversy about drafts that had not been produced, and I want to make sure that they have now been produced, because I guess there was a misunderstanding about the scope of the law. Okay. But that's all I have.
Okay, great. Well, let's get to it. Let's see if we can wrap this up by 6 and stay on time. Okay, Mr. Leger, if you're ready, we'll hear from the petitioner first. Mr. Borden, are you present? And let's ask if the respondent is also present.
Tom Borden, I'm present.
Okay, is there a representative from Rec and Park? Is there a representative from the Rec and Park Department? Okay, members, it doesn't seem like the respondent is present. If there are no objections, then I'll assume that we'll continue. Okay, hearing no objections, let's continue. Mr. Leger, if you're ready with the clock. Mr. Borden, you have 5 minutes.
You ready, sir?
Yes, I am.
Go ahead, sir.
Okay, so I requested information. Rec Park provided incomplete information, and I made a second information request, and they didn't provide any additional information. And there clearly were things missing, a large project area that involved quite a bit of the funding for the project. No map was provided, even though there were trail lengths and things that were part of their calculations. A second area on visitation was another project area where no map was provided. And the biggest thing was 1.5 million of spending from their stated budget was unaccounted for. And in my second request, I asked specifically for what that was, to account for the other 1.5 million, and they said they had no additional information. And then at the hearing that was just referred to, they said, oh, we didn't know he was asking for information about that 1.5 million. And they said they had it and that they would provide it, and they haven't provided anything since then. So, I mean, it's pretty, I don't know, if you have questions, I'll answer them, but it's pretty straightforward to me. They just don't want to provide the information.
Is that the end of your testimony, sir?
Sure.
Okay, thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner? Okay, hearing none. Is there a representative from the Recreation and Parks Department? Calling out for a representative from the Recreation and Parks Department. Respondent. Okay, let the record show that there was no response. Are there any persons or witnesses to provide any facts or evidence on behalf of the respondent? Okay, hearing none, members, the item is with you for questions and clarifications.
If I could, I'm sorry, go ahead.
Go ahead, Member Wong.
This is Member Wong. I was just going to ask for Member Stein to clarify on the documents that were being awaited that were mentioned in the complaint committee.
Can you hear me? Yeah. Yeah, well, I would say that the petitioner gave a pretty accurate summary of what happened, which was that, you know, there was a meeting where they said that there was like a $4 million budget for something, and then when they gave documents, it only showed about $2.5 million worth of expenses. And then they did say in the meeting, the respondent did say in the meeting that, oh, they didn't realize that, you know, there were other documents that would help explain that figure and that they would give them. So, you know, we didn't know exactly what documents those were, but presumably something that helped them create the budget for that particular project. So I was under the impression after that meeting that this case would probably be withdrawn if they came up with that documentation, but it hasn't been provided.
Okay, thank you, Member Stein. Member Schmidt.
Yeah, my take on this is I initially wondered if he simply was asking for documents that you would think would exist, but that they had not created those kind of documents. And so they had been responsive in that the documents didn't exist. At the hearing, I know that there were at least some documents that were acknowledged, that were responsive, that had not been produced. And I thought, I'm in accord with petitioner that it seems like there are some unproduced documents that were requested. And I think that's pretty much what the case is.
Okay, Member LaHood.
Yes, I have a question for Ms. Leger. Did we hear anything from the respondent, any acknowledgement of this meeting or response that they might have difficulty attending?
No, she didn't say she would have difficulty attending. When we talked about the item, the Brecken Park item that is the last case to be heard, I told her that this case had been withdrawn, and I expected her to appear for the other case, for this case.
I'm a little surprised based on what the committee members said, because usually when respondents show up for a committee meeting and indicate that they're going to provide additional records, for them not to show up is a bit surprising, but that's a clear violation not to have sent a knowledgeable representative to this meeting.
Okay, any other questions or clarifications needed? All right, shall we move to rebuttals? Okay, let's do so. Again, I'll call out for a representative from the Recreation and Park Department. Member Stein, can you mute, please? And Member Schmidt, can you mute, please? Thank you. Okay, petitioner, Mr. Borden, you have 3 minutes.
I would just like to say that this has been an ongoing pattern from Rec and Park, particularly their group that manages the undeveloped parkland in all of our city parks. And they've stonewalled many of my requests over the years, and that's why I'm sort of doggedly pursuing this to the end, because it's just there's public information. People want to know what they're planning to do and what their justifications are, and this isn't the first time I've had a complaint with you folks and over Rec and Park, and there's another one brewing right now. So I don't think my request was unreasonable. I think it's when I asked in my second sunshine request, this leaves 1.5 million unaccounted for. Please provide the rest of the budget that shows the missing cost elements. And then at the meeting, the Sunshine Task Force meeting, we had, for them to say, oh, we didn't know he was asking for the other elements that account for the other 1.5 million. We have that. We'll get it for him. And then, of course, then they did nothing. So it's an ongoing pattern, and that's all. Thank you.
Okay, thank you. Okay, members, time to deliberate and a motion.
Can I make a motion, or is it too early to do that? This is member
No,
stuff.
no, this is the exact time
Okay.
to do that. If
I
there's
didn't know if you went. Okay.
no other deliberation, to come up with a motion.
Yeah.
then
So I
go
would
ahead.
just make a motion to find a violation of Section 67.21 of the Sunshine Ordinance, failing to respond in a timely and complete manner to this request.
This is member Frazier, and I second.
Okay, moved by member Stein, second by member Frazier. Any comment on the motion? Any debate on the motion?
Do we want to add a violation for not sending a qualified representative to this task force hearing?
That was member LaHood.
I can add that.
Please cite the.
Oh, I don't have it in front of me. Does someone have this section in front of them?
I think it's 6721E. This is Vice Chair Yankee.
Maybe you want to add the amendment. But okay, I'll just say to add a violation of 67.21E for failure to send a representative to the hearing.
Member Frazier still would second that.
Okay, great. So you'll accept that amendment. Okay, the just so for everyone's edification, it's the last sentence of the paragraph. An authorized representative of the custodian of the public records requested shall attend any hearing and explain the basis for its decision to withhold the records requested. Just so you feel comfortable about what amendment you're making.
Yeah, I know what it is.
Okay. All right. Let's open up for public comment. Mr. Leger, I hand it to you.
Do we have a speaker?
Yes.
Are you ready, sir?
Yeah, can you hear me? And let me know when I can start, please.
You may begin.
Thank you. This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com. Also by mail, P.O. Box 170544, San Francisco, California 94117-0544. Thank you very much for the process you've just gone through and the motion that you've made. We certainly support that. Library Users Association, like many other folks, is very concerned that the whole city should be providing the information that people are legally requesting and entitled to. We're not a party to this, and we are not familiar with the case, but I'm glad you're insisting on attendance. And I do have a question for the consideration of the group, and that is whether this might be a willful violation. The complainant has said that there is a pattern and not only apparently of violations, but I'm not clear entirely whether the pattern also includes making promises, such as was reported having happened at the committee level, where they said they would get information and then did not follow through as promised, produced nothing as was reported, and then didn't even show up here. I think that that's a situation that the task force can, can make a determination on. I'm right now not entirely clear when or how or under what circumstances, but this certainly sounds like it might be an instance where the task force might want to consider violation finding and including it in the motion. Thank you very much.
Any other public comment on this motion? Last call for public comment on the motion. Okay, any other discussion, members? Public comments closed. Any last discussion, members, on the motion? Are we ready for a vote? Hearing no objection, Mr. Leger, please call the roll.
Member Stein?
Aye.
Member Stein, aye. Member Frazier?
Aye.
Member Frazier, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to find a violation of 6721 for failing to respond in a timely and complete manner to the request, and 6721E for failure to send a representative to the hearing.
Okay, great. I will call for a recess until 6:02.
Okay.
If there are no objections, we are in recess. Please mute your microphones and telephones, please, and turn off your video. Thank you.
How you doing, bud?
Sorry about that. I logged myself out by accident. Okay, are we all back? Looks that way. Okay, let's call the next item. We're back in session.
Yes. Item number 7, file number 20079, complaint filed by Shane Anderes against the District Attorney's Office and Chesa Boudin for allegedly violating Administrative Code Section 6721E by failing to respond to a records request in a timely manner, 6725, by failing to respond to an immediate disclosure request in a timely and or complete manner, 6726, for withholding kept to a minimum, and 6727 failing to provide justification for withholding of responsive records. I will read the conclusion, the italicized. March 16, 2021, the complaint committee found that the task force has jurisdiction. The records are public and referred the matter to the task force for hearing. In addition, the committee requested that the respondent provide information regarding how their search was conducted and what search terms were used. The committee also requested that the complainant provide information regarding the rationale in this specific case about attorney-client privilege and subsequent response from the respondent.
Okay. Complaint Committee Chair Schmidt, do you have anything to add?
Nothing from me. I think that sums it up for me, but I also, again, defer to members of my committee.
Okay, hearing none, let's begin. Are both parties here? Mr. Andrews?
Yes, I'm here.
Is there a representative from the DA's office?
Yes, Robin Burke from the DA's office.
Very good, thank you. Ms. Leger, when you're ready. Petitioner, Mr. Andrews, you have 5 minutes.
Mr. Andrews, are you ready?
Yes, I am.
Go ahead, sir.
So I had received a letter from Ms. Burke yesterday detailing, again, what they had done to search for responsive documents, primarily any emails to or from Mr. Boudin regarding Mr. Ostley. The letter confirmed that she had personally conducted an email search, that there was nothing responsive, that there were, did not produce anything, but indicated there were 5 responsive documents that were being withheld under claim of attorney-client privilege. I had emailed her before today's hearing late in the afternoon, so on somewhat short notice, but I said that I was inclined to go ahead and take this matter off calendar if she could go ahead and confirm that her search included some messaging software that I'm aware DA employees used, and also to confirm whether the search went back to January 19 of 2020 when I sent an evidence preservation letter to the DA's office to make sure that information had in fact been retained. While waiting for our matter to be called, I was flipping through the file and have come to realize that there were several documents that were responsive to this initial request that were not produced, that are in fact emails to or from Mr. Boudin referring to Mr. Osley that were not produced, that are not attorney-client privileged. And so I guess, you know, in the interim, I'm happy I didn't withdraw the matter from hearing, because at this point, I'm just questioning the accuracy or the thoroughness of the search for records. Sounds like I'm almost out of time, but I'll just reiterate something I heard Anonymous and other people saying, is that the ability to search emails, including attachments and embedded documents, is there now, so there shouldn't be a reason that information was not produced. And so I guess, you know, I guess I would want the committee to reaffirm the violation of the ordinance insofar as it failed to produce responsive documents, and I'd like it to go back and try again and confirm more precisely what it had done, since at least I think there are responsive documents that were not produced. I did email those to Ms. Burke and copied your committee, in fact, while I was waiting, just in the event anybody wanted to see what I was referring to so it could be easily circulated. Other than that, I have nothing else. Thank you.
Thank you very much. Are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner? Hearing none, respondent, you have 5 minutes.
Thank you so much. I am just getting a chance to review the documents that Mr. Andrews sent over, and I wanted to make sure that it's on the record that the request was received on February 4th, 2020, and it asked specifically for all records between January 1st, 2019 and present. So that would have been February 4th, 2020, specifically communication to or from Chesa Boudin regarding Thomas Osley. The email that Mr. Andrews sent over that he is calling into question is an email from Kelsey Russum to Chesa Boudin that was sent on January 22nd, 2020, and it has in it the results of a survey. And so when it was pulled, when we did the search, it wasn't initially pulled out as having any mention of Mr. Osley because it was an attachment, and I recognize that should have been disclosed. And then the second email that he's referring to is a letter that was sent on October 30th of 2020, so it was after the initial request, so we would not have had this to disclose at the time of the response, since it was months after the initial request.
Does that conclude your testimony?
Yes, it does.
Okay, thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the respondent? Okay, hearing none. Members, questions, clarifications for discovery? Matters with you. Member Padmanabhan?
Yeah, this question is for the respondent. I just heard you say that there were some documents. There was one document that was an attachment. So does that mean that your search term, that the search terms that you, the department or you used to search for these documents did not include attachments?
It did include attachments, and so I'm concerned as to why this one wasn't pulled during this search, but was pulled during a secondary search. And so I need to get with my IT department to understand why it would have missed this one this time, and it could be the way that I searched versus the way that they searched.
Anybody else? Member Schmidt?
Yeah, for respondents, what's the number of documents that would be responsive that your department has withheld under privilege?
There were 5 documents withheld under attorney-client privilege.
Okay, and so that hasn't changed at any time since you first determined the 5?
No, it has not.
Okay, and that and you've identified that it's in this case it's the client being the district attorney or the district attorney's office, and the attorney involved being the city attorney's office, correct?
Yes.
Okay, thank you. Nothing further.
Okay. Any other questions, members?
I would just like, I don't know if this is the time for it, but I wouldn't mind hearing from the petitioner about whether the respondent's statement satisfied their concerns about what they might or might not have received.
Sure. Petitioner, you may respond.
Sure, this is Shane Andrews. Yes, I'm satisfied, and I understand the difficulties of e-discovery and trying to locate things to produce. So I'm satisfied to the extent it sounds like Ms. Burke would be willing to go back and communicate with her IT person and to sort of confirm once more, perhaps with a little bit more detail, what specifically was done, just so I can be sure that in fact there isn't any other documents that have not been, excuse me, produced. There's only one concern I do have, and that's if I understood Ms. Burke correctly, she was indicating that, at least I think it sounds like she was under the belief there was no obligation to produce any documents past the date of the letter, based on the request that the DA's office produce everything from a certain date in 2019 to present. My common understanding is to present means on a rolling basis. So if my letter was sent yesterday, it would also include any documents responsive as of today, that it doesn't somehow cut itself off. And so I'm a little bit concerned, if I am understanding her statement correctly, that is what happened, that information beyond the date of the letter request was not even considered or reviewed for production. That would certainly be a much bigger problem in my mind, and I would want confirmation that in fact, when the DA goes back and reviews the information again, that it's from the date of my request all the way through present day. In other words, the date of production.
So I have a question, this is Chair Wolf, for Mr. Andrus. At the time that you filed the request, it was for what period of time?
I'm pulling up the request again. From January 1, 2019 and present.
To present, okay. Okay, thank you.
Okay.
Anything else, members? You ready for rebuttals? Okay, let's move to rebuttals. Respondent, DA's office, you have 3 minutes.
I have nothing to add.
Okay, thank you. Petitioner, you have 3 minutes.
Nothing to add other than identifying for the record that software app I was referring to is called Signal. There's a number of apps out there where you can communicate where the message, I think, automatically erases after a certain period of time, which can be set by the sender. But I still would like to know whether the Signal app was searched, given my understanding that employees use it, and because I had sent an evidence preservation notice that would have encompassed those communications. And so for me, I would want to know if that evidence preservation notice was communicated to the relevant or necessary parties. Otherwise, I'm concerned that there's more than a year's worth of potential responsive information that was simply allowed to erase over time, despite my notice.
Okay, thank you.
That's it. I'm done.
Okay, thank you. Okay, members, the matter is with you for deliberation and motion. I'm sorry, Member LaHood, go ahead. You have your hand up.
Yeah, I have a question about Signal and automatically disappearing messages. This is actually to the task force. Have we decided? Has that come up before? Have we had any previous, discussions where there was an automatic setting rather than somebody willfully going through and deleting old messages?
Not to my knowledge has it come up. I know that there has been some, I think there's been some news articles about the use of such, not just Signal, but even before Signal came out, like I think it was WhatsApp or something like that. There were a couple other similar type of apps out there that would do that. When the Smith versus San Jose ruling came out. But I don't think that there is, there's been any official policy for the city and county government. That meaning I'm not sure at all. Yes, Vice Chair Yankee, go ahead.
I guess just a question based on that. Maybe the respondent could clarify whether or not they did search any Signal app, I think it was called, messages that still remain. Was a search done on those for the respondent?
I did the search in January of 2020. And to be honest, I searched his phones, but I cannot recall all of the apps that I searched. I apologize. I've had a baby and been in pandemic childcare since then, so my brain is not as sharp as it once was. But I can double check with him.
Thank you.
Okay, members, is there a motion or any further deliberation or debate on the matter? Is there a motion?
I can make a motion.
Okay, member
Motion
Padmanabhan.
to find a violation of 67.21, failing to respond in a timely or complete manner. 67.27, first 67.26, withholding kept to a minimum, and 67.27, justification of withholding.
Okay, I think you meant 6721E.
6721E, that's right.
Great. Is there a second?
I'll second it.
Please state your name. Who is the seconder? Is there a second? Members, is there a second?
This is Member Frazier. I'll second.
Okay, thank you. Member Frazier seconds it. Is there any deliberation or debate on the motion to find a violation of 6721E for failing to respond to a records request in a timely or complete manner, 6726 withholding kept to a minimum, and 6727 for failing to provide justification or withholding responsive documents? Vice Chair Yankee.
Yeah, I guess that should just be for the task force, or maybe for the maker of the motion. What records in particular would you be referring to in that motion? Would this be the one that was the attachment that was dropped, or were there other ones that you're including within that motion?
I'm referring to the 5 documents that were withheld.
The 5, or those the ones under attorney-client privilege?
Attorney-client privilege.
So, or are we making an assertion then that they should not have been withheld under attorney-client privilege?
I'm making that assertion. Yes.
Okay.
Vice Chair Wolf, I would just state also that I'm more interested about the justification for the attorney-client privilege for withholding those documents, and the question then becomes who's that. I guess I think, as you mentioned, Vice Chair Yankee, that the DA's office is the client and the city attorney is the attorney of record. Is that correct?
That's correct. Yes, that was my questions to the respondent.
Okay, thank you. Okay, any other comment, any other discussion around the motion before I open up public comment? Go ahead, Member Schmidt.
Yeah, I mean, I would just say that I'll vote no when this comes on, because I don't understand trying to say there's a violation with regards to something that's clearly privileged. But that's just wanted to tell you that's my position on this.
Okay, Member LaHood and Vice Chair Yankee.
Yeah, in the event that this passes, I would like some clarification from the task force about the topic that came up with such and such date to the present. My interpretation of that would be the date that the request is made, because the present is forever moving forward, and we would not be able to set a boundary on what information we're talking about. I think if the request also said to date, and I would like updates anytime this comes up in the future, I feel like that is a different kind of request. But as saying such and such date to the present, to me, sets bookends on it, and I'd just like to know that that fellow task force members would agree with that should this go to compliance.
Well, let me just jump in for a second on that, says Chair Wolf. I would say that if there was a if there was a call for a rolling incremental rolling basis for providing documents, the question would then become, what is a reasonable period of time for it to come to the present? I don't necessarily think. I think at some point, when you take it to the point of filing the complaint, that at the time of the complaint, enough time has passed that the word present is somewhat meaningless, because it's obviously there hasn't been a response, for a fairly long time, as to what the status is. So I would think about it from that perspective. Vice Chair Yankee.
Yeah, I was just going to essentially kind of make the similar comment as Member LaHood did, that I'm not sure in this particular instance it was clear that present meant on a forward-looking basis. I probably would have, taken that to mean present as of the date that the request was made. So from my perspective, the only potential issue I'm seeing is the one attachment that was not included in the initial batch of documents released, but it sounds like it may have been released in a subsequent batch. But I'm in the same position as Member Schmidt regarding the attorney-client privilege documents. I've not heard any compelling testimony up to date showing that those should have been, or for some reason that privilege is being improperly used in this instance. So I'm a little uncomfortable with the broadness of the motion as it is.
Okay, so I'm hearing some dissension through through discussion, that there may be some concerns with the motion. Is there any amendments to the motion? Because if, as Member LaHood was pointing out, as this goes to be monitored by compliance amendments, they need a clear idea of what exactly the order determination is. So we've heard from Member Padmanabhan that she's referring to the 5 documents that were held under attorney-client privilege, and we've heard from Member Schmidt and from Vice Chair Yankee that the concern is really around a matter of maybe 1. Is there any meeting of the minds here for that? If not, we'll put it to a vote, and we'll.
I will also throw in there, since we didn't get clear. It sounds like the respondent, who was the representative here today, did not have a clear answer on whether the signal messages were also kept, or whether, searched, and whether there was. Whether if there was any automatic deletion happening, if that was stopped when the request was made to preserve records. I don't know. I would present that as a possible area to explore.
All right. I just want to express to everyone that if you have concerns about something, and you think that it's not correct, or you think that it should go in a different direction, I would attempt to put that out as a motion to make adjustments, and not see if somebody else picks up on it to make a motion, just so we're not spinning our wheels here.
I'm sorry, I was doing that to let the original makers of the motion modify, but I can come back with something if needed.
Okay. It's up to you. I'm just opening. I'm not making a request. I'm just stating that's your option and your prerogative under our parliamentary procedure. Vice Chair Yankee.
I'm not sure that now's the appropriate time for a second motion, since we already have one on the floor, but along the lines of Member LaHood, I think it might be worth, regardless of how this goes, exploring that and perhaps continuing this and giving a time frame wherein the DA's office can perform that search that Member LaHood spoke about and report back to the committee and to the petitioner if that search found any additional documents or not. Just confirm if that had been done or not.
Are you suggesting that we postpone this motion and move to a continuance?
That would be what I would propose, but I don't know if we need to vote on the motion that's already on the floor first.
You can make a replacement. Well, if we make the motion that's on the floor first, then then having a continuance is somewhat moot, because an order of determination would be somewhat final. So I would suggest, if you want to make a replacement motion for the one that's on the floor, that you do that as an amendment.
Okay, I would move to amend the motion for continuance to allow the respondent to search the Signal app messages and report back to the task force and the petitioner with those findings within, let's say, 30 days. That would be, by the next meeting.
And for it to be monitored by the Compliance and Amendments Committee?
Sure, the compliance with that, yeah.
Okay, great. Is there a second?
Actually, can I make a comment on that regarding that motion, or do we need a second first? I could second it.
We need a second first, unless you want. I would say get a second first, and then we can work on any clarifications.
I'm going to hold.
Okay, is there a second on Vice Chair Yankee's motion to replace the original motion to continue this file?
This is Member Wong. I'll second that.
Okay, moved by Vice Chair Yankee, second by Member Wong. Member LaHood, go ahead.
So my concern is that when we say 30 days out, but we think about setting what's on the agenda for the next Compliance and Amendments Committee meeting, I think we're actually going to end up more than a month out, because that is my you know what though, I guess that's how we do things. I mean, I can
we could do 15 days if you think that might be more time efficient to get it on your next agenda. I'm open to amending what I had stated day-wise. For LaHood.
I'm looking at the you know what, I don't want to hold people up while I'm searching the calendar, because our next Compliance and Amendments Committee meeting is the 25th.
This is Member Stein. Can we ask for this to be searched for or resolved within 1 week from the respondent? Do you think that we could ask the respondent if that's a reasonable timeline to do this small search?
I think that's a great question.
Ms. Burke, you're free to respond.
Yes, I think that would be okay.
Okay, so I'll change my motion to continue to have that done in 7 days instead of the 30 days.
Okay, and that some form of communication.
Yes, to be sent to the petitioner and to the task force that the Compliance and Amendments Committee can review it at their next meeting.
Okay, Member Wong, do you accept that?
I do.
Okay, great. Okay, so this is a motion to amend the original motion. We will vote on whether to accept the amendment. If the amendment is approved, then we will go back and vote on the new motion that has been replaced. Everybody understand?
Oh, what are you trying to do, Bruce?
Okay, so we have a motion on the floor that was made by Member Padmanabhan and seconded by
Member Frazier.
Member Frazier. And then we now have an amendment to replace that motion by Vice Chair Yankee and seconded by Member Wong to continue the file, and that the respondent will perform the functions, and I don't recall exactly what there was to do the search for in the Signal app. Was there something else besides that, Vice Chair Yankee?
No, that was it, the Signal app.
Okay, right. Within 7 days, and provide confirmation of the results of that to the petitioner, to the requester, complainant, and to the task force. And so when we vote on this amendment, if it is approved, then that will replace, that means we're approving or we're agreeing to replace the original motion, and then we'll call for the original motion because it'll be now a brand new motion. So this part is just purely operational, and the second one will be the actual approval of the motion. This is just an approval of the amendment. Okay. Any other discussion on the amendment? Okay, seeing none, let's open it for public comment only on the amendment. Any public comment on the amendment? Okay, hearing none, are we ready for a vote?
Chair Wolf,
yes.
Can we also verify that with Signal, we're also seeking information as to whether messages were being deleted automatically, and if so, if that was stopped when the request for those messages to be searched was initiated?
I would only suggest that there be an attempt made, because
yes,
apps like that do not have logs, I don't believe.
Right.
And if they don't have a log, there'd be no way to know. So
thank you.
But I mean, if you want to add that, I would, again, I mean, I want to extend this.
I'd like to make an amendment to the amendment that to the degree that it is possible, given the limitations of the app, that the respondent inquire as to whether the search was done at the time it was initially requested, and that we get a yes/no response to that, and if not, that the search be done now.
Okay, let's do this. We're just doing an operational thing to replace the original motion. Once we see if that's been approved, then your amendment would be appropriate. If this part doesn't make it, then your motion becomes moot. So just for the sake of procedure here, generally you don't do amendments on top of amendments. So the amendment is purely operational, first to either make a correction or to make an adjustment. Once we get through that, then the original motion will be on the floor. You're free to make any other amendments you want on top of that. Okay. Her signal is frozen, so I don't have an acknowledgement. Okay, there we go. Got an acknowledgement. Okay. Let's please call the roll, Mr. Leger.
Member Yankee?
Aye.
Member Yankee, aye. Member Wong?
Aye.
Member Line, excuse me. Member Frazier?
Aye.
Member Frazier, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Okay, I will read the motion as it has been amended. Member Yankee moved to amend the original motion to continue to allow the respondent to provide a signal search be performed within the next 7 days to confirm the results of that search at the next task force meeting. Now, are we going to include a review by CAC or not?
Yes.
Okay. Confirmation of the results of the next task force meeting, and that the issue continue to be monitored by the Compliance and Amendments Committee meeting. Next Compliance and Amendments Committee meeting. Does that make
Correct.
sense?
Yes.
Okay.
Okay, so that's our new motion on the floor. Now, Member LaHood, do you have?
Yeah. So based on the text of that motion, we know that a search is going to be conducted now. I would also like an answer to the question whether a search of the signal messages was done when the request was first made.
I'll second that.
Okay, I was going to ask, or is that a motion?
That was, yes, that was an amendment to, or do we need a new motion?
No, well, if you're going to make an amendment, that is a motion.
Okay, that's my motion, yes.
You move to amend.
I move to amend that in addition to requesting a response on the signal search, that we get an answer as to whether a signal search was performed when the Sunshine request was initially made.
Okay, is there a second?
Vice Chair Yankee will second.
Vice Chair Yankee seconds it. Okay. Discussion. Okay, hearing no discussion, let's open for public comment. Any public comment on the motion?
Yeah, I have public comment.
Okay, Ms. Leger, when you're ready. And this is a public comment on the motion to amend.
May I start?
Hang on. You may begin.
Okay. Yeah, I have two concerns. One is, even 7 days, it just seems like a very exorbitant amount of time for something as simple as searching through an app. I understand that, there are holidays and weekends, and I suppose some staff member would need to do this, but it's Wednesday, right? So I guess Mr. Boudin would need to get his, I suppose, I don't know where the phone is. I don't know if Mr. Boudin has like some sort of secretary or something that he interacts with in person now, but presumably he could get the phone to this person by tomorrow or by Friday at the latest. And then this person, it shouldn't take them more than a day. It should probably only take them, half an hour to do this, right? Maybe an hour. And so like a week seems like a lot of time. And then my second concern is if presumably all these records and stuff are supposed to be accessible. So why are public officials even using Signal in the first place? Like, why is this permitted? I don't know if this phone was a personal phone. Well, I presume it was probably a personal phone. But why does he have Signal on his phone, and why is this allowed if all of his communications are supposed to be accessible by public records request? So yeah, that's everything I had to comment on. Thank you.
Thank you. Any other public comment? Last call for public comment. Okay, public comment is closed. We're ready for a vote. Hearing no objections, please call the roll. This is on the amendment.
Okay, who seconded the amendment?
It was moved by Member LaHood, second by Vice Chair Yankee. And could everybody please mute their microphones? Thank you.
Okay, Member LaHood.
Aye.
Member LaHood, aye. Member Yankee.
Aye.
Member Yankee, aye. Member Frazier.
Aye.
Member Frazier, aye. Member Padmanabhan.
Aye.
Member Padmanabhan, aye. Member Neighbors.
Aye.
Member Neighbors, aye. Member Stein.
Aye.
Member Stein, aye. Member Forsley.
Aye.
Forsley, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member Wong.
Aye.
Member Wong, aye. Member Highland.
You're muted.
Aye.
Member Highland, aye. Chair Wolf.
Aye.
Chair Wolf, aye. So, I want to make sure. So now that we have an amendment to the motion.
So did it pass? Did it pass?
Yes, it did.
Okay. For the
Yeah.
record, the motion passed.
The motion passed, yes. I apologize. So,
Excuse me.
let me read the motion now that we have an amendment. So it would be to move to amend the original motion to continue to allow the respondent to perform a signal search within the next 7 days and to provide confirmation of the results of that search to the task force. This issue will be honored by the Compliance and Amendments Committee at their next meeting. And in addition, the task force is making an amendment to request a response on the signal search. You're gonna have to say it again, Lila, because I don't think I have it right.
It's not. Go ahead. You don't have to say amendment. It's just part of the motion.
We're requesting a response to the question as to whether a signal search was conducted when the Sunshine request was first made.
All right. In addition to requesting a response to the question on whether a signal search was to inquire when the signal search was originally performed, is that it?
No, whether a signal search was performed in response to the original request. And and if so, yeah, we want to know if it has already happened.
Yeah.
Yeah.
Yeah. Okay. Gotcha. So we're good?
Mm-hmm.
Yes.
Okay.
So now discussion on the main motion. Hearing none. Any public comment on the main motion?
Yes, please.
Wait for Mr. Leger.
So are you ready?
Yeah.
Okay. Go ahead.
Thank you. I think the clarification that member, I believe it was LaHood, said is very important, because if something is not searched at the time of the original request, auto destruction can easily destroy it, and then they can just make no record. So it's very important about whether they did the search at the time of the original request, Thank you.
Any other public comment?
Yeah, I have another public comment.
Go ahead, speaker.
Yeah, so I'm wondering, even if messages were deleted on Mr. Budin's device, is it possible that messages could be retrieved from the devices of the individuals whom he was communicating with? And if so, would there be some sort of mechanism for that under records request laws?
Any other public comment? Okay, hearing no public comment, more public comment. Public comment is closed. Are we ready for a vote? Hearing no objections, please call the roll.
I'm sorry. Member LaHood?
Aye.
Member LaHood, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Frazier?
Aye.
Member Frazier, aye. Member Padmanabhan?
Aye.
Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Could I get clarification? Is this the LaHood motion, member LaHood amendment?
Yes.
Oh, I thought, okay. I thought.
No. Let me clarify for you. This is the Vice Chair Yankee amendment to continue, and then there was an amendment that became now the main motion. Then Member LaHood made an amendment, an additional amendment with regards to the search of the Signal app.
And that's what this vote is on.
No, we already voted. That was the last vote. That last vote was approved.
Okay.
So now the main motion is both together.
It's okay. Is this the motion brought by member Padmanabhan that
No.
we're on?
No,
Okay,
the
we haven't gotten to that one yet.
Yeah, no. The motion by member Padmanabhan was replaced by Vice Chair Yankee's amendment. He made an amendment to replace the entire motion. Okay, that was approved. We all approved it, and then once that was approved, and now it became the main motion. Member LaHood made an additional amendment on top of the continuance that there should be an additional search of the Signal app. Okay, and we just voted on that. That was approved. So now we're at the main motion now with the two amendments. So now the main motion on the floor is to continue the item, and that the respondent should perform the search and produce any additional documents within 7 days, notify that they've done that to the petitioner and the Sunshine Task Force, and in addition to search the Signal app.
Okay, thank you for that clarification. My vote is then aye.
Okay, continue with the vote, please.
Okay. Member Wong?
Aye.
Member Wong, aye. Member Highland.
Aye.
Member Highland, aye. Member Chair Wolf.
Aye.
Chair Wolf, aye. All right, let's see. Member Yankee moved to amend the original motion to continue.
What's the tally of the vote, please?
All right, it's passed.
Okay, thank you.
All right.
All right, let's thank you, parties, for attending. Let's move on to our next agenda item.
Item number 8, file number 20092, complaint filed by Carl Kramer against the Department of Recreation and Parks for allegedly violating Administrative Code Section 6721 by failing to respond to a records request in a timely and or complete manner.
You told us that was pulled.
Yes, exactly. Yesterday afternoon at about 3:20.
Okay, so we've already done that at the top of the meeting, so let's move to item number 9.
All right. Item number 9, Sunshine Ordinance Task Force, election of officers.
Okay, members, this is our once a year election of officers. We have just 2 officers. They're the chair and the vice chair. If you're curious as to how the committee chairs get chosen, generally that is discussed with the chair. The chair will make those nominations, and generally they're affirmed by the task force at a subsequent meeting. If there is no changes, then there's no changes, and everybody can remain where they are. But this is an opportunity to kind of move the deck chairs around. I do want to kind of present a proposal. And before I ask for nominations, a proposal that I and Vice Chair Yankee have been talking about, which can of course be countered by any nominations for the positions, which will take one officer position at a time. We would like to propose that both of us be reelected, and for anyone who is interested to shadow us. We're suggesting this because there are several operations in process that we're deeply involved in as officers, in addition to the current backlog and developing a smooth transition for all of us, including staff. Jumping into the fire or running through a gauntlet, we feel would not be conducive for the flow, and that is current and evolving. For anyone or more of you that would be shadowing us, if we all agree that you feel comfortable to start assuming those positions, we'll then agendize the elections again and reopen them and implement this process again. Like I said, doesn't obfuscate anyone who wants to step up now and to either nominate someone or nominate yourself. So the floor is open for nominations. Member Neighbors.
In the interest of gender balance, I would like to nominate Member LaHood. I believe she has a lot of experience. She's chaired my committee I sit on with finesse and mastery of parliamentary procedure. I think all of us benefit from having leadership from a woman on any committee, but particularly this one, because it's been a while since a woman has led the committee, and we have someone who is very experienced to do that. So that's my nomination.
Member LaHood, do you accept the nomination?
First of all, I want to say thank you. I am flattered. Is the nomination a nomination to shadow or a nomination for the role?
I think Member Neighbors was suggesting for the role.
It's for the role.
First of all, I want to say thank you, and I really really appreciate the nomination, but I do not think that I can accept it in good conscience, even though I appreciate and endorse your sentiments, but I don't think that I have the time that the position requires. And I would like to see someone who can really devote the time and energy to it. My responsibilities with the public press are significant enough as it is, and I do not think I could do the position the justice it requires at this time. So I would love to see someone else. In fact, maybe I can pass things along, and or maybe I'll stop there and see if there are other nominations. But thank you. I appreciate it. I cannot accept it at this time.
Okay. Thank you. And I want to also express same sentiments that member Neighbors put forward. I mean, I have been sitting in this position for quite some time, and for sake of a better answer, it's by default because nobody else wanted to do it. So that's why we're kind of suggesting that proposal. But nonetheless, please, all nominations, the floor is open.
I could turn around and say, Chair, if I may, Member Wong, who has now been on the task force for quite some time and has also been on the Compliance and Amendments Committee, and is very thoughtful and deliberate and knows the ordinance in great detail, I think would be a great candidate for either position. And I would nominate her for the position of her choice, or encourage her to consider the possibility of shadowing, because I think she would also be great in a leadership role with this organization.
Okay, well, let's start with one at a time. So let's start with the chair's position. Member Wong.
Similar to you, Member LaHood, I really appreciate the nomination. I actually have a similar situation where I have a lot of responsibilities as a board member of the League of Women Voters. So I don't think I have time to commit to doing so. I think I would be interested in shadowing in the future, but I think at this time, maybe not.
Floor is still open, folks. We're starting with the chair position.
This is Member Highland.
Go ahead.
I'd like to support the current chair and vice chair, as stated, and I'm actually the longest serving member on this current task force, and I had the pleasure of serving with Chair Alison Washburn, both as her vice chair and as her acting chair when she left. So it hasn't been too far in the distant past that we've had a lady chairing this task force, just to make everyone feel a little more comfortable. But having said that, I'm happy to support either a female for either role also. We just want to pass that on to everybody. But I do like the idea of keeping the current leaders we have. I like the idea of shadowing. It's kind of like, at a golf club, you select the captain and the vice captain. The vice captain becomes the captain the next year. And that's really a shadow role. Seems to work well. for a couple hundred years in most golf clubs. So I like that idea. So I would like to nominate Bruce Wolf for chair. I'll end on that.
I'll accept the nomination, considering the just considering the proposal I made, and also but encourage folks to step up and see if you are, to really see about taking up the helm of this at some point. I really am trying to wind down, and but I don't want to just do it, cold turkey, and then things get thrown in kind of a tizzy, and because there's just there is a lot of moving parts to this right now, and considering the we're still kind of working remotely. City Hall's not open yet. Like I said, I'm open to do it, but I would prefer not to do it for the entire year.
It's a 1 year. It's a 1 year term from today, correct?
Correct.
So, in your comments, it sounds like you do want to hand over the reins. Is that what I'm hearing?
Yeah, like I said, I'll accept the nomination. It's actually until the next election. So whenever the point, usually the terms end at the end of April. So it'd be the first meeting of May that the election takes place on an annual basis. So, like I said, I'm willing to do it again by default, but I really would. It would be so helpful if folks would consider shadowing me and whoever the vice chair ends up being tonight to assure smooth transition.
Well, not to get ahead of ourselves, and I'm going to do exactly that. I'd like to see Member Yankee as vice chair and potentially as chair next year, because he would have shadowed you this last year and the coming year. And this is also the first time in 10 years we've had a full complement to actually have this vote, to have any meaningful import, because we've always been short of members and the timing and whatnot. So I would be comfortable with that transition plan.
Well, let's get through the election first before we talk about transition plan. I'm putting that out there in my acceptance speech of the motion. Member LaHood.
Perhaps this is premature, but would our bylaws allow for us to have a vice chair and then a second vice chair, so that there's a more established sequence?
No, we would have to amend our bylaws because that doesn't exist. But by creating kind of the shadow experience, I mean, that I'm wondering if that might not lend to that, because the purpose of the shadow is that whoever is interested in doing that, they would have, they'd be involved in all the, administrative functions that goes on. And, it's, if somebody feels like it's manageable for them, then, come however much time it takes for them to feel comfortable, we'll hold another election. But I like your idea.
Also, do we have to be careful of having too many people in the mix and not violating our own meeting laws?
True.
So what is that number?
Well, it's really a matter of the what's being discussed. I mean, it's much of the work that we do is purely administrative. It's logistics. It's not really regarding the merits of the matters at all. So it's purely in a lot of ways logistics, and sometimes having meetings to kind of determine whether we're gathering information for the task to present to the task force. Usually it's no more than 1 or 2 people to do that at a time. It's really administrative matters at that point. And we do, as often as we can, keep as notes for those things that, if people want to ask, we make sure that there are notes and there's, recording of a record that a meeting had taken place, that kind of thing. So, we try to keep with our transparency, and what we're doing here. So don't want to spend too much more time. If there's the last call for nominations for the chair. Okay, hearing none, is there a motion?
So moved.
Okay,
Member Frazier seconds.
Okay, moved by Member Highland to elect Bruce Wolf as chair, seconded by Member Frazier. Any further discussion on this motion?
I would just quickly say kudos to you all for thinking about longevity and institutional knowledge. So just appreciate the amount of thought that was put into this idea.
And I'd just like to say for the record that, I'm very sensitive to the lack of diversity that the task force has had for many, many years. And the fact that we have, as I would say, as close to complete diversity now. We have very good balance now, and I just want to be sensitive to that. And I understand, the reluctance, but I really try to encourage everybody to think about taking up the leadership at some point or another. It's only for a year. It's a good experience into city government and all of that, and so I appreciate your confidence in me in continuing on. So thank you. Okay, seeing none, let's move to public comment.
Yes, please.
Mr. Leger?
I'm working on it.
Okay.
So are you ready?
Yes.
Okay. Go ahead.
Thank you. For the sake of impartiality, since all of you judge my complaints, I'm not going to make any comment for or against any person, but I will point out something Member Highland, I believe, said about meeting transparencies when these kinds of offline meetings happening. Has actually was discussed in one of your own committee hearings against, I think, the Board of Supervisors. The Sunshine Ordinance goes beyond the Brown Act, and apparently even congregations, when it's not necessarily in your subject matter jurisdiction, appear to constitute a meeting under the Sunshine Ordinance. And so I would hope that that's just taken into account if there's more than 2 people, since obviously your committees are 3 people and your full task force 6 people would constitute a meeting. The other side of that is obviously I have those conversations that have appeared both at the Board of Supervisors and the chair and vice chair. I very much look forward to you all enacting some sort of way of consolidating complaints. As was discussed a second ago, it would be very, very helpful for all of us. Thank you.
Any other public comment?
Yeah, I'd like to make a comment.
You ready?
Yeah. Can I go ahead?
Go ahead.
Yeah, I think it might be helpful to have more public input during this whole selection of chairs or leadership roles or what have you. And I mean, I don't know exactly how ceremonial these leadership roles are, whether or not they actually have much of an influence on the outcome of individual cases. But you know, it seems like it might be a good idea to have to allow for more public input, just so as to foster more public trust in the task force. Yeah, thank you.
Any other public comment? Last call for public comment. Okay, hearing none, ready for a vote? Hearing no objections, please call roll.
Member Highland? Member Highland? I think you're on mute. I can't hear you.
Aye. Technical issues. Aye.
Member Highland, aye. Member Frazier?
Aye.
Member Frazier, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to have Bruce Wolf as chair passes.
Thank you very much. Okay, let's go to vice chair. Floor is open for nominations.
I have a question. Do we need to nominate Matt Yankee?
Yes, because
Okay.
elections are fresh every year.
Okay, I would like to nominate him.
Okay. Matt, do you
I'll
accept
accept.
the nomination?
Sure. Thank you.
Okay. Any other nominations for vice chair? Nominations for vice chair. Okay, last call for nominations for vice chair.
This is Member Wong.
Member
So can I say that I would be open to shadowing for vice chair?
Absolutely. Doesn't need to be voted on. You just step up and do it.
Awesome. Okay, let's do it.
Okay. All right, last call for nominations for vice chair. Okay, hearing none. Let's get a motion on the floor. Is there a motion to elect or re-elect?
This is Member Frazier. I move to re-elect Member Yankee as the vice chair.
Is there a second?
This is
Second.
member. Oh, okay. It's fine.
Go ahead.
Well, this is member Stein. I'm happy to second, but I think someone else seconded.
That's okay.
Okay.
Moved by member Frazier, second by member Stein to re-elect Matthew Yankee, member Yankee, to the vice chair officer position. Any further discussion on the motion? Okay, let's open it up for public comment. Any public comment?
Yeah, I'll comment again.
Ms. Leger.
Are you ready, ma'am?
Yeah.
Okay. Go ahead.
So yeah, I guess I don't know, it just seems somewhat problematic that, you know, you have the same chair and vice chair. I understand that. I guess Mr. Wolf is the only person who's willing to be the chair, so that's how you end up with Mr. Wolf as the chair. I don't know that maybe that's I guess the discussion with Mr. Yankee as vice chair is that you're grooming him to become the chair in the future. I don't know. It wasn't quite clear to me, but you know, this was the makeup last year, and so I don't know. I feel like organizations are healthier when they don't necessarily have the same people in the same leadership positions over and over again. So yeah, that's my comment. Thank you.
Any other public comment?
Yes, please.
Go ahead, Anonymous.
Thank you very much. Again, not going to comment on or against the person, but in the context, I think it's a great idea to have a person who is some person who will shadow whoever is the vice chair as to do future leadership. I agree with the prior speaker, but I think the issue is, and I think this is to the public at large, more people need to actually volunteer for the SOTF. And I assume it's quite difficult since you guys have to work very long meetings and you're unpaid, and someone's going to hate you no matter what you decide. So I hope more people would volunteer for the Sunshine Orange Task Force. As far as I know, in the last two, and then maybe there is more diversity and more fresh opinions. And again, whoever is the vice chair, as I said with the chair, I hope you do institute these, create new procedures that allow more efficient handling of multiple complaints and so on. I know it's been discussed for quite some time. Thank you very much.
Any other public comment? Okay, hearing none, public comment is closed. Are we ready for a vote? Hearing no objections, please call the roll.
Wait, I see the hand raised.
Sorry.
I don't see a hand.
I want to, sorry, I do want to say that I do tend to agree with what the one of the speakers said in terms of even if things are going great, it's great to have different people in the different roles. I think this is kind of a transition year of sorts because I think it was, we weren't even meeting as a body or something at one point. So I think that continuity is really important at this time. And I will also say that I think that member Yankee also does a great job. Like he has contributions to the minutes. And I think those type of administrative things are really, really important. So, and also member Stein as well. So I think that that's the administrative things that have to really be in place.
Member Wong.
Yeah, along those lines, in response to an earlier comment, I just wanted to say that members of the public can make comment and give contributions to who is on the task force before we are appointed during the Board of Supervisors Rules Committee. So that is one way to have input. It's not specifically to the leadership within the task force, but something to keep in mind for future task forces.
It's a very good point. Thank you. All right, are we ready for a vote? Okay, please call the roll.
Member Frazier?
Aye.
Member Frazier, aye. Member Stein?
Aye.
Member Stein, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to elect Matthew Yankee as vice chair has passed.
Okay. Let's move to the next item.
Item number 10, take position and make a recommendation to the Board of Supervisors on AB 703, AB 339, and SB 116. I have provided links to everybody, so it shouldn't be difficult to get to.
Okay, so let me just preface this by saying that the Sunshine Ordinance Task Force doesn't take positions, but we will consider a position to make as a recommendation to the Board of Supervisors. Let me just clarify it that way, so nobody misinterprets that our authority or lack of authority at this point. So what we're asking the board, what we will do is we're basically asking the Board of Supervisors we'll review these, we'll have some discussion about them, and then see if there's any recommendations that we want to make to the Board of Supervisors on a position that we recommend for them to take on these items. I'm wondering, Vice Chair Yankee, if maybe you want to take the lead on this item.
Sure.
Go ahead. Passing the gavel to you.
So I think we can look at the first one, which was pull up the AB 339. There's a variety of proposals within this bill, so some of it would, a lot of it has to do with extending some of the remote meeting options through, telephone or video conference, and kind of setting some parameters for that going forward. I believe it used to, if it still does, there was some language in there about having interpreters, but I bet that may have been changed, or that may have been in another bill. So that's 339. See, the next one is AB 703. And this one also has to do with teleconferencing in meetings, and this is the one that I believe has the this one have the interpreter in there. That may have been stripped out. These look like they were recently amended since I last took a look at them, but they're both the concept on both of these is remote meetings, teleconferencing options, and kind of setting some parameters going forward to deal with both of those.
The interpretation provision, I think, is in AB 339. It says interpretation services should be provided if requested.
Okay, yeah.
And there's also something which I'll just throw in because I kind of had a question about it. It changes the foreign language requirements for publication of, I guess, notice of meetings. And I guess in the past it was if over 5% of the population spoke a different language, you were supposed to put those notices in that language, and it changes it to the two most common languages after English. So I don't know if that's going to decrease the amount of languages that notices were provided in. It seems like it might.
You know, if you click, that's what I thought. If you click the link, it looks like that stuff's been stripped out into the.
Oh, has it?
That was published yesterday. That's why I got confused here.
Oh.
Yeah, if you search for the word language in the document, it only, I think, appears once, not with a strike through.
Yeah, so I think the prior iteration of this language had it, and then if you click the actual live link, it looks like that must have just been amended yesterday. That's why I got a little thrown
I
off.
reviewed it like 2-3 days ago.
Yeah, changes that fast. So yeah, this month's date published 5/4. So it looks like this is now just focusing on, and actually this says, it looks like it's just was amended to apply to city councils or county board of supervisors, the governor jurisdiction of at least 250,000 people. So it wouldn't even extend, it looks like, to boards and commissions or to any of the smaller cities or counties within the state. So I don't know if
Chair Wolf is on mute.
I'm sorry?
Oh, Chair Wolf was speaking, but he's on mute.
I'm sorry. Member Neighbors, then Member LaHood, then myself.
Thanks. I'm wondering about how we can make a recommendation when the language is still changing in such a profound way. I mean, one of the things that really stood out in AB 339 to me that I was really interested and excited about was an emphasis on two-way video participation as a requirement, and now that's been struck out, right? So is there an end date for edits? Can we make recommendations once those edits are done? I'm just a little bit concerned about making a recommendation while edits are still in process.
So are you saying something like support if amended? Or
Well,
that we should recommend that specific amendments be made in order before a position is considered?
I think it more that we would need to say, as of our reading on the specific date, that is our recommendation, because changes are going to happen between the time that we stop looking at it now and the time that they read our recommendation, right? So we're really only recommending the document that we are looking at right now. It's like making rolling requests that never end.
Okay, Member LaHood.
Yeah, one thing that jumped out at me right away in 339 was the the telephonic option or an internet-based service option. And, you know, it seems like the pandemic is lifting and maybe this won't be as important, but we don't know if we're going to end up back in this situation again. You know, we could, even with all the vaccines, there could be another wave. And I'm concerned with the internet option being allowed as an only option, especially since we know, based on people who participate in our meetings and who don't necessarily have broadband access that would allow them to be limited to have to have internet access to participate. And I would like it I would like telephonic access to be mandatory and internet access to be nice too. But I don't think we can say that internet access only will be sufficient to serve the entire community.
Okay, I'll go next. I'm very concerned about this for a number of reasons. One is in the opening of this particular chapter 54.953, it talks about, and this does not have a sunset date. This would be permanent. it says all and edited in, open and public. I'll just say quote and unquote, which means the amendments. All, quote, open and public, unquote, meetings, open quote, of a city council or a county board of supervisors that governs a jurisdiction containing at least 250,000 people, unquote, shall include an opportunity for members of the public to attend via a telephonic option or open quote or unquote an internet-based service option. Now, what about those cities that are less than 250,000 people? What happens to them? There is no provision for them. Now, halfway down, when you get to G, it says this section shall remain in effect only until December 31st, 2023. And as of that date is repealed, but not anything before that. It's section G that will be repealed, those amendments, but not anything above that. So I'm really concerned that now public comment will be basically nullified for any city or county or even unincorporated area of a county. Well, that would be a county, I guess, that has less than 250,000 people. I don't understand where that comes from. Let's see. The other parts are, and then it goes down to D, all open and public meetings of a city council or a county board of supervisors that governs a jurisdiction containing at least 250,000 people shall comply with the following requirements. And there's not much addition to that, except there is a there's no it removes the requirement for having to register. It's basically there's a repeal for what was 5C, stating registration for a public comment period is permitted so long as instructions to register are posted. We don't require that here. There's no requirement to register for public comment. People can remain anonymous in that way. So that's not really a big deal. Moving down the line, then you get to G, and we get to this part that has a sunset clause. But read the very first line, 54954.2A1. The posting requirement is being repealed for 2 years. I'm sorry, 3 years. Almost 3 years, probably be 2.5 years by the time if this passes. Okay, and it removes most of the meat of the Brown Act for running a meeting. So I'm pretty concerned about that. If you go down to the amendment, the actual replacement language, there is some repetition, but it basically only talks about teleconferencing, the allowance for using teleconferencing, but the removal of the posting requirements as far as time, the 72-hour advance, poof, it disappears. So I'm not sure how we feel about that. I'll stop there. Any other comments on this before I call public comment? think it's worthwhile to have public comment before we make a motion on this one, because it's so, so deep. Okay, let's open up for public comment. Ms. Leger?
Yes.
Do you have a speaker ready?
Yes.
Hello?
Yes, they're ready.
Okay.
And one more as well.
Anonymous, go ahead.
Thank you. So I actually wrote to the task force strongly encouraging you to recommend that the Board of Supervisors actually endorse this. And I can no longer do that, and I feel embarrassed for asking you to. Obviously, the text was completely changed on May 4th, days long after I and many other organizations were supporting it, and I agree. This is completely watered down. It is it's basically a Trojan horse to weaken public meeting laws now. It wasn't that way before, and I don't at all think that you endorse it. Everything discussed today is correct as of the May 4th version of this bill. And it takes, I don't understand this 250,000 people limit. It wasn't there before. The fact that it only applied to City Council and County Board of Supervisors, why is that? That's ridiculous. The or versus and issue, ridiculous as well. The issue that the automatic, the fact that these things are only remaining in effect until certain days and then repealed, that's absolutely ridiculous. And it is very strange that I mean, I don't know if a lawyer didn't do their job by making G apply to like the entire section instead of just maybe the online access, which is like what they probably or wanted for COVID. But it's absolutely ridiculous. It would absolutely gut the Brown Act. So I would strongly urge the task force not at all to support this AB 339 as it is written, the version May 4th amended by the Assembly. Thank you.
Next speaker.
Yeah,
Hang on.
can I go ahead? Okay.
Nope. Not yet.
So I can start?
Yeah.
She'll let you know.
Okay.
Go ahead.
So I guess I don't really understand the point of recommending the Board of Supervisors, because I guess this legislation hasn't actually passed yet. So is this one of those things where the Board of Supervisors is going to like make a motion supporting one of these things or opposing one of these things? Because like, those motions don't really have any teeth. I don't know if anyone in the state assembly actually changes their mind because the Board of Supervisors in San Francisco said that they either like this bill or didn't like this bill. That being said, and then of course here the Sunshine Ordinance Task Force is like, so you're trying to tell the Board of Supervisors to have an opinion so that they can tell the state assembly to have an opinion. I don't know, it's just a little bit absurd. But that being said, as far as having an opinion, and now I'm trying to tell you to have an opinion. So yeah, chain of absurdity. That being said, as far as concerns about these bills, I've not read them myself, but from what's been discussed so far, one thing that wasn't mentioned that I would be concerned about would be accessibility issues. I do agree that certainly having these available to people without internet access is important, but I think it's also important to make sure that these are accessible to people with various disabilities, such as visual impairments or hearing impairments. For example, this meeting does not seem to be very accessible to somebody who has a hearing impairment, and so making sure that meetings are accessible to people with various disabilities would be important, and making sure that the legislation covers for that.
30 seconds.
Okay. And then privacy and security would also be something that I would be concerned about. Okay, so yeah, that's all I have to say.
Next speaker.
Who's next?
You.
Okay, let me know when I can start.
Go ahead, sir. Go ahead, Mr. Warfield.
Thank you. This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com. Also P.O. Box 170544, San Francisco, California, 94117-0544. Thank you very much for all of the comments that I've heard. And excuse me, I'm particularly concerned with and glad that I believe it was Lila LaHood who expressed a concern about a certain or instead of and that is there seem to be a number of instances where there's talk about permitting or requiring that there be and I've lost the place, but there's an or instead of an and between telephone or telephonic access and internet access. And if you take that to mean either one is okay, then that means only internet access would be okay. And I think that is very wrong and very inappropriate. Telephone access has a tremendous breadth of breadth and depth. I'm not sure what the figures are, 99% or whatever of folks have access to a telephone. And I have a number of times quoted, I'm not sure how often I've quoted it here, but we had a city report, the so-called City and County of San Francisco Digital Equity Strategic Plan 2019 to 24, which put numbers on the folks that do not have internet access from home. And what that found was not only that there were over 100,000 people in San Francisco without internet access or high-speed internet access, but that this, when you look into who among those people is the most affected, you find what you'd expect to find, but it's very radical differences. So, for example, among people with 25,000, I have a little longer than that on my time, but anyway, income-wise, those under 25,000 and under have 59% have access from home. 200,000 and above have 98%. Racially, it's whites on top, blacks on the bottom, Asians and Latins in the middle. And age-wise, the older segment of population has a very strong drop-off in terms of access. So cutting telephone access is a very, very bad idea and should not be endorsed. Thank you.
Any other public comment? Last call for public comment. Okay, hearing none. Is there a motion or any further discussion? Let's start with that. Any further discussion or motion? Okay, I'll make a motion. I move to recommend to the Board of Supervisors to oppose the amendments in Assembly Bill 339, in that removing the jurisdiction around the minimum of 250,000 people is inappropriate and not within the spirit of open meetings and transparency. Not transparency, open meetings and the public's right to voice their concerns. That's number one, part one. Part two, that the repeal of section 2, section 54954, that's 54954.2, be restored. And that, which includes the interpretation services, and to include the suggestions and sentiments of the public testimony we heard tonight. On this matter. Is there a second?
Could we hear that back?
You want me to read it, Bruce? I typed it.
Sure.
Moved by Bruce Wolf to recommend to the Board of Supervisors to oppose the amendments in AB 339, and that removing the jurisdiction around the minimum of 250,000 people is inappropriate and not within the spirit of open meetings and the public right to voice their concerns. That the repeal of Section 2, 54954.2 be restored, which includes the interpretation services and include the sentiments of public testimony heard tonight on this matter.
Okay, let me clarify this. It's actually 3 parts. So the second part is, let me rephrase that. The repeal of section 54954.2 is abhorrent to the spirit of sunshine and public meetings. And 3, to include the sentiments and suggestions that the public commenters we heard tonight be included in our recommendations.
Are you ready for a second?
Yes, ready for a second.
This is member Neighbors. I'll second.
Okay, moved by the chair, second by member Neighbors. Any further discussion? Okay, let's take public comment on the motion. See if we missed anything. Any public comment? Last
Yeah.
call. Okay.
You ready, sir?
Yes, please.
Go ahead.
Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, P.O. Box 170544, San Francisco, California 94117-0544. Thank you for the motion. I think perhaps it would be an improvement to make some particular specifications about the contents of the public comments that you're including by a general mention. But I think that some of the specifics are very important. What I was concerned about with what I was concerned with and spoke about specifically was what looks like a permitting of only internet access rather than both telephone and internet access. And in my view, that would literally disenfranchise millions of people. With about 1 in 8 people in San Francisco, and with the population of California, I don't have good statistics for the state, but I think that there would be huge numbers of folks who would simply not be able to make public comment, to participate, to listen, and so on and so forth. So I think that some of the public comments that were made might, particularly with regard to the way that the person can access the meeting.
Member Stein, hold on a second. Please stop the clock. Member Stein, can you please mute?
Yes, I am.
Thank you.
Sorry about that.
Go ahead, Speaker.
Thank you. So I would just urge that perhaps for there to be a specific mention of the most basic thing, and that is how do people access, how do they have an ability to listen to a meeting, and how do they have an opportunity to make public comment? And if you have the or instead of the and, you would potentially disenfranchise very large numbers of people. I'm just hoping that you might put that. I'm just hoping that you'll consider putting that and perhaps some of the other public comments more explicitly rather than in a kind of a general reference without specifics as to the content. Thanks very much.
Any other public comment? Okay. Ms. Leger?
I didn't hear. Was there another public comment there?
I believe so. Our audio is beginning to deteriorate here.
Sir, are you ready?
I am.
Okay. Go ahead, sir.
Thank you. Going along with what Mr. Warfield said, I would also suggest a more specific. So I'd suggest that the motion say that the Board of Supervisors should recommend that Section 1-54953-B have the phrase containing at least 250,000 people be struck, have the or in the first sentence of that subsection be replaced with and optionally. So it requires a telephonic option and optionally also an internet-based service option. To strike the phrase containing at least 250,000 people on Section 1-54953-B. To also strike Section 1-54953-G, which is what removes in-person access after December 31st, 2023, and then to strike Section 2 altogether. And at least my reading of and that's specifically, I would ask that you reference May 4th, the May 4th, 2021 amended version so that they know exactly what you're talking about. Because if they don't do this and this law passes, it will seriously harm public access. Thank you.
Any other public comment? Okay, so I'm still of the mind that we just ask them to oppose it and not try to fix it or amend it. I mean, if you look at the authors, it's none of the San Francisco, I don't believe any of the Bay Area representatives. So that's one signal. But I think that I think just asking them to oppose it completely with the reasons that have been brought forward by us and by members of the public here, I think included, should be sufficient enough for them to consider our recommendation for them to oppose. Yeah, Vice Chair Yankee.
Yeah, I didn't. I was just scrolling down. I just want to make sure that everyone realized before we vote on this. I'm not sure if it changes anything, but there's that big part that was read and struck out, but looks like they are adding a new section at the bottom at 54953. If you down to like the bottom quarter of the page, you have to scroll down that far. There's a bunch of other language that they added. I just want to make sure everyone saw that.
Yeah. It's somewhat repetition of basically what it does is it repeals 54954.2 and replaces this language called section 2, which would be new.
Right.
And still the red part would just disappear.
Mm-hmm.
So it's it's a can of worms.
Yeah.
So, all right. Anything else? We've got 2 others to consider that I think we can get through fairly quickly. Ready for a vote? Okay, please call the roll.
Chair Wolf?
Aye.
Chair Wolf, aye. Excuse me. Member Neighbors?
Aye.
Member Neighbors, aye. Member Frazier?
Aye.
Member Frazier, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Stein?
You're
Member
muted.
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Nay.
Member Schmidt, no. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland? Member Highland?
I think he is absent.
Member Highland,
Yes,
absent.
absent.
So I will read back the motion moved by Bruce Wolf, seconded by Member Neighbors, to recommend to the Board of Supervisors to oppose amendments in AB 339. Excuse me. That removing the jurisdiction around the minimum of 250,000 people is inappropriate and not within the spirit of open meeting and public right to voice their concerns. That the repeal of section 54954.2 is abhorrent to the spirit of sunshine, and that public meetings be restored, which include their interpretation services, and include the sentiments of the public testimony heard tonight on this matter, and include our recommendations.
Yep, sounds good. Thank you.
That was just for 339?
That's only for 339. Let's move to the next one. Is AB 703. This is fairly simple. It's basically supports how and expands how location and remote call-ins work. I don't see there being much of a problem with this one. Anybody? Nope. Okay, let's get some input from whoever public is left.
Do we have any public commenters?
Sure, I can speak to Anonymous.
Go ahead, sir.
I would transfer all of the supportive comments I had originally in writing sent to you about AB 339 to this bill instead, and anything that improves access in any form is always a good thing. There is no reason that anyone who can't, necessarily have the ability to come to a particular place to have a meeting, those people should not be disenfranchised. Thank you very much.
Any other public comment? Okay, members, there a motion? Any other questions regarding this? Yes, Vice Chair Yankee.
Yeah, I was just going to note that it doesn't appear that there's a lot of support or activity around this bill. If you click into the bill analysis portion of it, tab for that, there doesn't seem to be anything. There were, many organizations that were lined up to support the other one. It's sometimes you'll see this. I've noticed, dealing with some other statewide legislation where you'll get related types of bills, and most of the activity kind of shifts away from one into the other. Not that we can't take a position on this one, but it seems like this one doesn't necessarily have the traction one way or another that the other one does. Just more of a note.
Yeah. I think it's worthwhile, though, to at least let the Board of Supervisors know that we're tracking these, and that maybe their state legislative committee, isn't or should be. And maybe they have, maybe they missed it, but that if this they do get a phone call, at least they have our blessings for it.
Mm-hmm.
I mean, obviously it could be far more expanded than this, but I think this is kind of a transition back into kind of in-person meetings, but still retains the ability and the provisions for remote meetings, because we never know what's going to happen with COVID. So, and this is obviously, this is actually, I think, it looks like it's referencing Executive Order number N2920. Yeah, okay. So basically saying that not a meeting notice, but has to be an agenda. And it basically addresses the public observance of the meeting to go beyond just in person. So I would go to support this one. And I'll make that motion to recommend to the Board of Supervisors to support AB 703, in that it would improve access to public meetings.
This is Vice Chair Yankee. I would second that. And maybe we just put the language in the bill as of April. Looks like this is April 29th, just in case.
Okay.
This language starts getting tweaked again, also.
Yeah, just in case something happens.
Like the other one, exactly.
Yeah, agree.
You're putting that language into the motion. Is that what you're saying, Matt?
Yes, I agree.
Okay, where? What language?
That it's as of the published date, April 29th, 2021 at 9 p.m. It's the timestamp that's on the legislation itself.
April 21, you said?
April 2/9
Okay.
at 9 p.m. Okay, any further discussion on this? Now that a motion's on the floor, any public comment on the motion?
We don't have a second. Matt, did you second?
Yes, I seconded.
All right.
Any public comment on the motion? Okay, seeing no public comment, are we ready for a vote? Seeing no objection, please call roll.
Chair Wolf,
Yes. Aye.
Chair Wolf, aye. Member Yankee,
Aye.
Member Yankee, aye. Member Frazier,
Aye.
Member Frazier, aye. Member Padmanabhan,
Aye.
Member Padmanabhan, aye. Member Neighbors,
Aye.
Member Neighbors, aye. Member Stein,
Aye.
Member Stein, aye. Member Forsley,
Aye.
Forsley, aye. Member Schmidt,
Aye.
Member Schmidt, aye. Member Wong,
Aye.
Member Wong, aye. Member LaHood,
Aye.
Member LaHood, aye. Member Highland,
Absent.
absent, okay. The motion is to recommend to the Board of the Supervisors to support AB 703, that it would improve access to public meetings, and support the published date of April 29, 2021 at 9 p.m., seconded by Matt.
Correct. Okay, thank you. The next item is SB 16. This is on a different subject. That's pretty important. This one, it's very simple and straight ahead. It adds a redaction provision to protect the anonymity of victims and whistleblowers with regards to the release of peace officer records, the release of records on peace officers. That's pretty much the long and the short of it. Yeah, member Neighbors, go ahead. Sorry, I missed it. Seeing your hand.
I wanted to point out that this proposed bill has a lot of support from advocate organizations, other organizations, including ACLU, Asian Americans Advancing Justice, the Ella Baker Center for Human Rights, the National Association of Social Workers, and Voices for Progress. There's many that supported it as well, and I'm excited about being able to pass an endorsement on to the Board of Supervisors for this bill.
Is that a motion?
If folks feel like going straight to a motion, I would, but I would assume you want to discuss.
You can go straight. If somebody makes a motion, it will be honored at any time.
Okay. I move that we endorse SB 16 to the Board of Supervisors to underscore the public's right to know, particularly in terms of the investigation of alleged incidents by officers against members of the public that could potentially be disguised as personnel records.
Let me just wordsmith that a bit. If we can't make endorsements, is that the motion would be to make a recommendation to endorse Senate Bill 16 for the Board of Supervisors to endorse Senate Bill 16. Is that okay with you?
Yes.
Okay. Is there a second? Member Schmidt.
Second.
Okay, good. Moved by member Neighbors, second by member Schmidt. Is there any further discussion on this? Any public comment?
I do have one question about
Oh, yes. Member Stein, go ahead.
I don't know if any of you can answer it, but it talks about a civil fine of $1,000 a day after that 30-day limit for providing information, but it doesn't say who pays that fine. And I wondered, does that mean it's a fine on the agency? Does that mean it's a fine on the keeper of the public record? Does that mean it's a fine on somebody else?
Can you specify the section and paragraph, please?
I'm so far down. If you just do a search, text search for civil fine, the first instance appears like almost towards the end of the bill in a section 10, but section 3, item.
So it's section 3, section 832.7 of the Penal Code. It would be, let's see, 10.9.8.7.6.
I mean, it's also mentioned.
4.3.2. Hold on. 2.1. So it's B10. B1. I'm sorry. B1. Nope.
No, it's also mentioned in the. Now that I see it, it's also mentioned in the second paragraph.
B10
of the bill.
But that's only the preamble.
Yeah. So beyond the preamble, it's way down in there, and I just don't know.
B110. It says for every day. It says except to the extent temporary withholding for no longer period is permitted to pursuant to paragraph 7, records subject to disclosure on this subdivision shall be provided at the earliest possible time, no later than 45 days of the requested disclosure. For every day beyond the day. So you have to start at the top to see who this applies to. So you have to kind of scroll back to the top and see who the subject of this is. It says, except it's provided in section B, the personal records of police and custodial officers and records maintained by a state or local agency.
So it's the agency that's fined?
Right. Then you go to B, and it says notwithstanding subdivision A, because this is where paragraph 10 is. The following peace officer or custodial officer personnel records and records maintained by the state or local agency shall not be confidential and be made for public inspection. So yes, it's the state or local agency.
Okay.
And then it says there, it says in 10, it says an agency shall be subject to a civil fine not to exceed $1,000 per day. That would go to the requester of the record.
Okay.
Okay. So we have a who moved? I'm sorry, I lost my place here.
Member Neighbors.
Oh yes, member Neighbors and seconded by member Schmidt. Let's open up for public comment.
Yes, please.
Mr. Leger, we have a speaker.
No, I know. Are you ready, sir?
Yes, I am.
Go ahead.
Thank you very much. First, I wanted to thank you all for agendizing this. I know I wrote you a note. There's a lot more organizations that were stated recently that are in support of this. It's one of the best improvements to public records access statewide in a long time, and it's a lot more than just the sections that were just read out. There's permanent retention of all SB 1421 style records, not just for 5 years. The fines are amazing. I one day hope that the sunshine markings will be amended the same way, and they're based on time, not just oh, we'll give it to you whenever you want. No, there's a deadline. They're doubling the party's reasonable cost and attorney fees. There's a punitive part to it. This is really just an amazing law, and it limits the attorney-client privilege with respect to factual information. And as you know, the city attorney is claiming that in some of my complaints regarding body cam footage and other incident reports, just factual information that happens to be in the possession of the city attorney, is all attorney-client privilege. But this law, I really hope it passes. I strongly support any support of this law. If it doesn't pass the state legislature, well, we know where their priorities lie. Thank you very much.
Any other public comment? Hearing none. Any last discussion points on this one, members? Okay, ready for a vote? Hearing no objection, please call roll.
Member Neighbors?
Aye.
Member Neighbors, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Frazier?
Aye.
Member Frazier, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland? He's not here. Okay. Chair Wolf?
Aye.
Chair Wolf, aye. The motion that the task force moves to make a recommendation to advise the Board of Supervisors to endorse SB 16.
Correct. Okay. Thank you very much. It was good work there, folks. Let's move on to our next item.
Yeah, give me a minute. I have to pull it up on my computer. I have to pull it up, so I'll be right with you. Okay, this report was prepared last week, April 30th. It included all the dates for committees this month, including the task force. So next Tuesday, we will have an EOT meeting. The agenda's been set. I've spoken to Chair Highland. Following that week will be complaint committee, and following that week will be compliance and amendments. And then the same schedule I have set for June. This is so that we can get through our backlog, at least at the committee level, and then start working it towards the task force level. I've got dates through July. We had several complaints that came in April. We have gone down in some of our numbers. 2020 in section 3, 2020 last month, there were 100 cases, and we were able to eliminate 11 of them, which is good. But the cases for 2021 did rise. So if you look at both last month's figures and this month's figures, there really isn't much of a difference, except that we're starting to make headway in 2020. So that's good. I have provided the minutes of the complaint committee. I've provided communications from Anonymous to the task force. And I have also provided a list of emails from March 31st to April 24th that I received from members of the public or people inquiring about the task force and that I responded to. And that should be in with your packet.
Any questions or discussion for Cheryl?
Yeah, I'm happy to answer questions.
Okay, if not, then open it up for public comment. Public comment?
Yes, please. I'm not sure what I heard. Can you hear me?
Yeah,
Yes,
just wait a moment.
Second.
Sure.
Second. You ready, Mr. Warfield?
Yes, tell me when I shall start.
Okay, you can start.
This is Peter Warfield, Executive Director, Library Users Association. We can be reached at libraryusers2004@yahoo.com and P.O. Box 170544, San Francisco, California, 94117-0544. I noticed that the minutes, the draft minutes of the complaint committee of April 20th, which is just a very recent moment, are in here, and I'm not clear why. As I mentioned much earlier, when you were reviewing the year-and-a-half-old minutes, that I had understood, and again, I can't quite say from where, that I had understood that if something is not approved within 6 months, if one of the committee minutes is not approved within 6 months, that it will be approved by the full task force. So I'm not really clear how this finds its way into the administrator's report, why or what that means, or whether it's going to be approved at the next meeting, or it's not clear to me at all. With respect to the contents, I want to appreciate and thank whoever drafted these, that the one point at which evidently I spoke, and I know that there was an important supervisors meeting at the same time. I've sometimes said you had once changed your meeting dates so that you would not coincide with the major meeting of the week at the Board of Supervisors. But in any case, evidently I made public comment only once on item 11. And there I'm appreciating that you have Peter Warfield, Executive Director of Library Users Association, Box 170544, San Francisco, California, 94117. But there's missing the email address. And the idea that one might only be able to reach us by U.S. Postal Service, I think, is, well, quite wrong, and it actually would put a blockade in the ability of somebody to reach us if they had email and wanted to reach us in that way. Additionally, the
30 seconds.
The zip code extension is missing. It should be 94117-0544. So I'm not sure what to say about this, since you're evidently not approving this, but it's being included here, and I don't know how long that slightly erroneous reference will stay unchanged, or when it's going to be approved somewhere. So I'd appreciate some clarity on that. And
time is up, sir.
Yeah, thank you.
So I'll ask the question, Cheryl. Why is this set of minutes for the complaint committee in your report?
Because you've asked me to put complaint committee meeting minutes in the administrator's report. That's why it's there.
Okay.
I usually include it.
Yeah, so I'm sorry, I failed to recall that, and it's not in my notes. That I should have announced at the beginning of the meeting. So from this point forward, I've asked Cheryl to include the complaint committee minutes in her report so that you all will have it as part of the to review before the meeting. Now you can just go to the website and do that, but I felt that if it wasn't too much extra trouble for Cheryl to include it in her report, and I would just tell you that it's there and will be there at the next when the next agenda comes. Because otherwise, besides just getting kind of a report from the chair and committee members before we hear the hearing, you should at least be able to see if there was anything more pertinent or substantive that might help you understand the case better, considering that we're not receiving the legal memos anymore. So it's just to provide as much information as possible. We'll probably have to include now all three of the committees. I think it may be better just to, maybe we'll just put the link to it, maybe somewhere in the agenda at the top, maybe, or something, and make it easier to find. But I think it'll just help all of us get prepared for these hearings, because they're not getting any easier. So the more information we can get ahead of time, the better. It makes our streamlines getting through the meetings tonight. And I'm glad we're getting to the end of this meeting before 9 o'clock tonight. So
I have a question, Bruce.
Yes.
With these minutes, would you also like me to continue providing the staff notes for all task force meetings?
Yeah, I think that's definitely appropriate. I think any and all information, if you feel that it's redundant at that point, then we can talk. Let's review that. Before I make any hasty decisions, let's you and I review that, and we'll see if it's too redundant. If it's too redundant, then we don't need the staff notes anymore, and people can just refer to the minutes.
Well, the one thing that staff notes does do is it collects per case all the case minutes. Like if I have, just like tonight, like for the Anderes case, I mean, if there were other committee minutes, then you could see all that information associated with that particular case. That's the one thing it does do, is keep it in order.
Okay, well, let's review that, and we'll figure that out. We're just trying to find ways to help everybody get familiar with the case as quickly as possible, not having the legal memos anymore. Okay, any other public comment?
Yes, please.
You ready?
Yes, I am.
Go ahead.
Thank you. One thing I would note is a member of the public informed me they were wondering, why do my communications to the SOTF from the public get posted here, but not other people who are sending kind of advocacy or some other kind of position for the SOTF to take. So, and I think the issue looking at that person's emails is maybe it's not realized that people are sending, a public correspondence to SOTF. So if you could maybe make it clear on the agenda or somewhere, how is it that someone is supposed to give you this kind of advocacy material? I know I put like a big disclaimer that this is public communication to SOTF for forwarding to all members, but I know other people want to be able to do the same thing, and so you may want to make that more clear. That's all. Thank you.
Okay, we'll review that. Thank you. Any other public comment?
Yeah, I'd like to comment. May I be in?
Not yet, just a second. Go ahead.
Yeah, so I'm also a little bit concerned that I guess that Cheryl acts as sort of a gateway as to which communications do and do not reach the SOTF. I think there's a fairly easy, well, I don't know, at least something that would be a sort of a Band-Aid for this. Another thing that concerns me is that people who submit, who file complaints, I don't think all of them are aware that their complaints become public records. In looking up cases, I found very detailed personal information. You look at these complaints and you get email addresses, you get names, you get all sorts of information that it's quite detailed and personal. And I think a lot of these people don't realize how much their information they're not just only giving to the SOTF, but to the general public. So, maybe just making it clear that to everyone that, hey, this is very public and it's open to everyone, and just publishing all records, all sort of communications so that everyone can see what is being sent to the SOTF. It's not just having it sort of being sort of, I guess, cherry picked, if you will. Yes, I've sent a number of communications to the SOTF and I have not heard anything, which is somewhat concerning. I've sent an email regarding the SFDCC's failure to provide Zoom information to the public despite their legal obligation to, and so it'd be very nice to hear back on that, and or at
30
least
seconds.
to have some sort of idea about when one might receive a response. That would be very much appreciated. Right. Thank you.
Any other public comment? Okay, hearing none. Any last words, folks? Okay, hearing none. Let's thank you, Cheryl, for your work. Much appreciated. Let's go to the next item.
Okay. Item number 12, announcements, comments, questions, and future agenda items by members of the Sunshine Ordinance Task Force.
Floor is open. Member Vice Chair Yankee.
Just real quick comment, and I think we've talked about this before, but I noticed that this agenda, and I thought it was really helpful, included blue underlined hyperlinks for the bills that we were looking at in item number 10. And I was wondering if whatever, Cheryl, you did to make that look blue and underlined, if maybe we could use that same technology to link to all the attachments on all the other items so that the members of the public actually know that that word attachments is an actual hyperlink. Looks like the PDF we use supports that, so if we can maybe do that going forward, this is a suggestion.
Yeah.
Good suggestion. Anybody else?
This is Member Stein. I'll just raise something that I raised in the complaints committee, is that I would, if there's any scope for it, I would love for us to look at how these packets were done and consider making a table of contents for them that is also linkable through hyperlinks, and just have every document that appears have its own link, maybe even as an appendix or something like that, so that we don't have to just scroll through hundreds of pages of repetitive, documents, essentially. So rather than see an email 20 times in one case, it just had it was one item that you could link to in an appendix for that case.
Yeah, that has been a subject over the years. I think that can be done. I mean, the cover page has the page number that each section begins with. I prefer using the full function of PDF to create somewhat of like bookmarks or kind of little booklets, you know, like little kind of folder sections for each one. So it makes it kind of more, kind of creates containers or folders for each of the sections. Because yeah, there's a tremendous amount of repetition, and some of these files go on forever.
I just think it's a lot of eye strain, and it
Yeah.
just it's so much more arduous to go through a packet if it's a 2,000-page packet and 1,000 pages of it is repetitive.
Right. And frankly, without some sort of explanation of what you're jumping into, it becomes somewhat of a, you know, either wild goose chase or down a rabbit's hole, you know, trying to figure out, you know, which end is up. And it would be really bad if, you know, you're heading down some path thinking that you understand what the case is, and then it really is something else. So yeah, it's we have to deal with the loss of our legal memos at some point. And I have been trying my darndest to get a meeting with Supervisor Haney to see if we can get, you know, some, like even a 0.5 FTE, just to do that on a monthly basis. You know, like a paralegal or something like that, because I think we're suffering in a lot of ways by not having that. So, all right, anything else? Member Schmidt.
Yeah, two things. One, just real, I know I've got the complaint committee, and I'm trying to, you know, add a case or two every time I can. The backlog to me is such a, I don't know. I don't know if I should call it an embarrassment, but I feel like I don't know if we can really claim we're doing great service if we're like a year behind. And so to me, I just want to emphasize that clearing this backlog is my primary goal. The second thing I wanted to note is I don't know if it got completely addressed, but I thought, as did Member LaHood, I thought the idea that Member Wong could do the shadowing sounds superb. And, you know, I'm going to guess that that's probably everyone just was on board with it, but I didn't know if it got spoken out. And so I just wanted to say that about Member Wong, that I think it would be great if she could do that. That's all.
Great. Let me just answer a question about the backlog a little bit. We've been trying to work out a way to make that happen because of Cheryl's. The way forward to make that happen is to make all the committees meet monthly. So the ones that are currently bi-monthly, which are CAC and EOT, they would be made to meet monthly only till we can get through the backlog, which I anticipate could be probably no more than 3 months, maybe 4 months. And this is just on the jurisdiction intake side. Okay, once that is complete, then we would possibly think about having 2 task force meetings a month until we can get to a more manageable place with the backlog. Now, a lot of the backlog is coming from a single requester. We've been in contact with that requester, and we're working out a different process because of the type of requests that are being made for that. And so that's still in play. We've had some meetings about it, and we're trying to see, frankly, if some of those we can identify certain kinds of complaints that are more kind of rudimentary, kind of non-compliance, where the merits, it isn't about the merits of the case. It's more about like pure timeliness, where there's no contest, that kind of thing. And maybe having the task force take them up instead of having to run them through the complete complaint process. So, for instance, if we can identify respondents that declare no contest on a violation or an alleged violation, then we don't have to run it through our regular SOTF process. We would have a different process that would be that would expedite it, so that way we can get it off our docket real fast. So still in discussions about that, trying to figure it out. So we have something to present all of you. It's still kind of not at a proof of concept place yet, but it's ongoing. Member Neighbors.
I think Member Schmidt's hand was up before mine.
He just spoke.
Oh, his hand is not really up. There. One of the things that that I've observed on the compliance committee is that we could really expedite our decision making if we had a searchable trove of orders of determination. And I know we've talked about it before, and I hate to bring it up again. But to me, that's a really high priority. And I'm wondering if there's anything that I can do to support that happening. I'd be happy to do that. I just think it would make a huge difference, not only in terms of how swiftly we could move, but also just how consistent we are with our own selves,
Okay, so I will report that Vice Chair Yankee, myself, Ms. Leger, had met with Department of Technology twice to discuss this matter. And the first time they said, let's look into it, because we keep getting told by the clerk's office that they're trying to get us kind of an additional license to use the Legistar platform, which is how the Board of Supervisors track their legislation. And I think the Board of Permit Appeals, I think they were doing for them too. There was one other commission that it's under the Board of Supervisors, I think, or not part of the executive branch or something. We did have a meeting, I think it was last week, with the director of Linda Grinnell of Department of Technology. She just reported that yes, there's something up with the contract. They're now involved and are helping to try to make that, try to push it through and make something happen. So I would just say let's just hang tight a little while longer until we get a final, kind of answer what's going on there. There's movement on it. There's attention on it. And with that, I'll just also add, we've been asking not to use Microsoft Teams anymore because it's clunky. And the Department of Technology has made a decision to for everyone to use the WebEx. It's kind of the new updated or upgraded WebEx version. And they're encouraging us to use it. She is actively sending trainers to work with the folks that run our meetings, and has committed to work with the clerk of the board for the Board of Supervisors to completely move to the WebEx system, so we don't have to have this clunky kind of bridge or adapter or connector between the phone service and the online service. And it'll be a lot more controllable and will allow people to log into our meetings and see our faces. It will help also with sharing of the screen for the parties. It'll be a lot more controllable. So anxiously waiting for that report to come. So it's just an update. I don't really have anything of more substance to tell you than that. Anything else on people's minds? Any future agenda items? Okay, well, think about it. You can send it to me. Let's open up for public comment and go home. Or most of us are already home. But what I mean. Public comment.
Yes, please. Yes.
Go ahead, sir.
Which one of us is speaking?
Mr. Warfield.
When do I start?
Now.
Peter Warfield, Executive Director, Library Users Association. Library Users 2004 at yahoo.com and PO Box 170544, San Francisco, California 94117-0544. I guess I thought that these were all future agenda items being discussed by the members, and many of the points I think are very valuable and important and should be on future agenda items. With respect to labeling, and part of that would be, for example, how are things working for folks and how aren't they? There could be an agenda item concerning what is happening with regard to backlogs or improvements generally, administratively, and so on and so forth, up to your call. But for the moment, let me say that labeling the attachments, I think, is critically important with respect to clarity, for example, for folks who get the agendas on paper or who print them out. There is no linking when there's paper. And if you look at the Library Commission, for example, they simply name the documents that they are linking to. And that would answer one of the folks' questions. Where are you jumping into? I think Bruce Wolf mentioned that. What are you jumping into? Well, if you can link on a particular item or one of the items that's included in an agenda item, then I think that is much easier and also clear for folks who are using paper. The backlog has been referred to a number of times. Again, I think that's a potential agenda item that ought to be discussed in all of its various aspects. Library Users Association was on the notice for today's meeting, and because we only got 2 days notice, the thing was sent out 2 days before the deadline. I'm sorry, not 2 days notice for the meeting, 7 days notice for the meeting, but only 2 days notice for the deadline to include material in the agenda. And that just wasn't enough for, I think, a reasonable preparation. And I, therefore, immediately, hoping that that immediacy would also help fill the spot that we had vacated, I tried to very quickly respond and say we can't do that. There are many withdrawals or continuances, I think, that could be avoided if there were greater time for being able to provide the information. And as far as clunky teams, I appreciate very much that everybody is equal. I would hate to have to bring something with somebody else who's got visuals and I don't. Thank you.
Next speaker.
May I speak?
Go ahead, sir.
Thank you very much. So I agree with all of the original comments about how to improve the agendas. They've been discussed now at multiple meetings. And I think part of your improvement of agendas is digitizing these complaint packets so they're not just huge images with broken OCR. Sometimes you can't really search through them. Nearly all, not all, but nearly all city records and the complaints are filed electronically. And obviously for the people who are sending you paper stuff, you have to scan them. But for most of us, and especially the city, it's always in digital form. And it would just be a lot easier to handle those records with those, table of contents, hyperlinks, etc. I had a similar experience to Mr. Warfield, and I think the second one of my complaints, there's a slot here that wasn't used today because another one of my complaints was scheduled, but we couldn't do it because the mayor's office said, well, he can't attend today. But I would hope that, when people can't come, and I accepted it, it was more than 5 days, it's fine, and so it never came here for a continuance. But it would be nice if, whenever someone can't show up, someone else can take their space. And I think I've said that before as well. Part of that backlog is 24 Prop G complaints, all filed by me, about 24 department heads who do not, record information required by the law. And I mean, unless you just say, well, we're just not going to care, I don't know what to do about that, right? Because we need to enforce the law, and I would hope that they would accept it. 1 out of 24 has said, oh, we just accept it. The other 23 want to fight. So, I mean, I don't know what to do in those cases other than suggest consolidation or something like that. But if they're not going to accept that they have to do what the law says about, for example, recording the subject matter of their meetings, I mean, I don't know how is the city going to be held to the Sunshine Ordinance otherwise? Thank you very much.
Next speaker.
May I begin?
Just a second. Go ahead.
Yeah, so I agree that it'd be nice for us to be able to have WebEx, log into the WebEx platform to, see what people are doing and see whatever happens in the chat log, if anything happens in the chat log. And it was unclear to me if this is happening citywide or if this is just for the SOTF. It sounded like this is a citywide decision, which is nice, so that there'll be some uniformity in platform now. But I have concerns that that if the city is just transitioning totally to WebEx and no longer using MS Teams and Zoom and the whole plethora of various video conferencing solutions that they were using before, records that from previous meetings that may have been kept and such will be lost. And I'm sure there are a lot of people who might want to request records from they might want to find chat logs from an MS Teams meeting, or I believe that one can also send messages even when there's not an official meeting in session. So people might want to look up these things. And so if there's some way that these can be archived, that would be very important. I've also brought up concerns before about the use of the chat box, which the police commission, for example, does regularly. And of course, that's just the group chat, and I don't know what sort of direct message chat occurs, obviously. And so I feel like there needs to be some sort of regulation on that and on visibility of that going on forward. Okay, thank you.
Okay, thank you. I will just say that there is no citywide mandate from the mayor for the executive branch of government to use any specific technology. So take it up. If you're concerned about the different departments that are using various different platforms, I'd start making your inquiry in that direction. Okay, no more public comment. Let's move to the next item.
Item number 13, adjournment.
Is there a motion? Oh, nobody wants to go home.
People.
I'll do it. This is Member LaHood. I motion to adjourn.
Is there a second?
This is Member Neighbors. I'll second.
Okay, moved by Member LaHood, second by Member Neighbors. We, all those in favor, just say aye.
Aye.
Opposed? Okay, seeing none, we are adjourned at 21:03. Thank you, folks. Good job. 3 minutes over. All right. Have a good night, everybody.
Hey, Victor, you gonna stick around?